I'm going to call the meeting of the Brockton Zoning Board of Appeals for the month of December 2024 to order. The board members that are sitting on tonight's hearing is Member Steve Leanis, Member Monique Greenberry, Member Fire Chief Brian Nardelli, Member James Sweeney, myself, Chair Kenneth Galligan. Our Zoning Enforcement Officer, Buildings Commissioner and Clerk of the Zoning Board, Mr. James Plouffe, and our recording secretary tonight is Monica Fagazzo. Before we start the meeting, I would ask everyone that has a cell phone or electronic device, either shut it off, put it on silence, or if you need to use the phone for any reason, I would appreciate if you take your conversation out in the hallway. I will tell you that this meeting is being televised, and it will be repeated several times throughout the month of December. Prior to the start of tonight's hearings, there is an opportunity for any petitioner to withdraw without prejudice. Is there anyone here tonight that wants to withdraw? Seeing none, we will go forward. We have 10 cases tonight, correct? Nine cases, I'm sorry. We do have 9 cases tonight. The way the meeting will be run is I will call the case. The petitioner or representative of the petitioner will come up to the podium, explain what your request is for either a special permit, variance, use variance, or whatever. And when you have concluded, I will then ask the board members if anyone has a question relative to the testimony that has been given. Once that is completed, I will close that portion of the hearing and open up for public discussion. This is a public hearing. Everyone has the right to be heard. I will ask if there is anyone here that wants to speak in favor first. When that is completed, I will ask if there's anyone here that wants to speak in opposition. When that is completed, I will ask if there is any elected official in the room that wants to be heard on the issue. Lastly, I will generally ask if there is anyone in the room that has a question relative to the testimony that has been given tonight. That then will conclude the public hearing. At that point, I will then open it up for discussion among board members. This is where the board will deliberate based upon the facts that have been presented at the hearing tonight. At some point, you'll hear a board member make a motion to grant. In order for a petition to be granted, if all 5 members vote in the affirmative, the petition will be granted. If the vote is 4 in favor and 1 opposed, the motion will be granted. If there is anything less than that, say a 3-2 vote, 3 in favor, 2 against, the petition will be denied. Following tonight's hearing, the meeting minutes will be put together at the building department, and you will be notified as to when the final decision has been made in print. At the end of the motion that you hear from the board members, I will ask the clerk to call the roll. Each member will then vote in the affirmative or in the negative. The clerk will then notify me what the vote is. I will then notify all of you whether the petition has been granted or the petition has been denied. Board members, we all set?
Yes.
Have you got anything out, or are we good? Good? Good. All right. The first petition before us tonight is petition number 2466. The petition of Brockton Country Club, care of attorney Philip Nazarella, 1063 North Main Street, Brockton, Mass., seeking relief from Article 6, Section 2739 and 2743 to allow the use of a food truck on the premises, utilizing the club's commissary and selling its products to customers in a C2 zone located at 265 Samuel Avenue. Now, I have a question. Is that correct, C2?
No, that's a residential zone, R1.
Yeah. All right, is that a Scrivener's error on here? It is a Scrivener's error. All right, so we are in a R1B zone, not a C2 zone.
Correct.
Correct. Got it. Thank you.
Mr. Chairman, with your permission, members of the board, Attorney Philip Nasrallah, for the record, representing Brockton Country Club. Brockton Country Club has been in existence in the city of Brockton for over 125 years. At the inception of the club's founding, I think we all will agree that whole area was probably very rural and very few homes, and it was well before zoning, well before the designation of single-family homes. During the course of decades and decades, homes started to be built there, and in the 60s, as you know, we started designating zones in the city of Brockton, and that became a residential zone, thereby leaving Brockton Country Club as a non-conforming use, which it remains as today. And over the course of the following years, different additions had formed with the club, having a restaurant, having a bar, food services, and they would utilize the services of either a cook, chef, catering service in order to accomplish that. And over the past several years, not unlike many other entities which butt up against each other, zones of different classifications, there had been issues in and around the use of the club and the activities that took place there. Minor issues. Approximately 7 or 8 months ago, back in May of 2024, the club received a communication from our building inspector indicating that there were several violations he wanted to have accounted for, and he considered the extension of the non-conforming use not to be valid without recognition and acknowledgement by the zoning board in the city of Brockton. The building inspector also pointed out that there were initially 9 stipulations that the club had to comply with back at the time that building permits were granted. And the inspector, in his letter of May 17, 2024, indicated that all of the 9 stipulations were complied with, and the club was in compliance with those regulations. The concern centered around the use of the kitchen at the club, the commissary, and such that, and I will submit valid concerns that the use was only to be for members-only functions for the food and beverage services of the club. It cannot be used to prepare food for any other use, such as commissary for a food truck. It may have been at that time, but the building inspector said it should not be. Also was the fact that it could not be sold to non-members of the club. Food could not be prepared and sold to non-members of the club, only to club members. The final or designation by the building inspector was the country club is solely for the use of members of the club through their corporation. The facility cannot be used by third parties. Since that time, the board had formed or changed somewhat at the Brockton Country Club, and Mrs. Teresa Creedon is the treasurer of the club. We had reviewed these stipulations and took action following the building inspector's recommendations. Since this letter has come out, we first had stated to the commissary chef, Diggs Food Truck, there will be no more advertising on Facebook or any other medium of selling food to third parties. There will not be any pickup by third parties of any food at the grounds of the Brockton Country Club unless they are members. There will not be use of the kitchen for any functions other than for the members of the Brockton Country Club. This was all done with the expectation in the interest of satisfying what I suggest were valid concerns by the building inspector. Mrs. Creedon will verify that the club has taken a very open-eyed view of this and is also monitoring it. There had been other somewhat collateral concerns about the parking lot is not locked and secure at night. The gate is not locked. Brockton Country Club has also undertaken that function to make sure there is security so third-party trespassers don't go in there, kids don't zoom in with their vehicles and do donuts and disturb the neighborhood. So now it's been locked down for that point. So what we are here for this evening is that the commissary is used for the cooking of food for club members. The commissary stores food for the club. We are looking to extend the non-conforming use by allowing additional food to be stored for Mr. Deegs, who later will take the food, puts it on his truck, and takes it elsewhere to cook and serve to the third-party non-members. A rather inconsequential use of the kitchen facility or the kitchen refrigerator. So if he buys 30 pounds of meat and another 15 pounds for his private business, he puts the 45 pounds of meat in the refrigerator, 30 for the club, the other 15 are taken away. They're not cooked on the premises, they're not served on the premises, they're not cooked on the truck on the premises. It's out of there. So for the extension of the non-conforming use pursuant to Chapter 27-39, the board must find that the use shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. So the existing non-conforming use is allowed to have the kitchen and store food. By allowing the additional use of the storage of food, is that substantially more detrimental to the neighborhood being that whole zone? And I would find it very, very unlikely that that would be a substantial detrimental use. And bear in mind, members, when the legislature designates and creates these ordinances and statutes, they take particular care with the use of words. They don't substantial detriment, not minor inconvenience, not an insignificant distraction or annoyance. Is it a substantial detriment to the surrounding neighborhood? And to store food in a refrigerator that he's not doing anything with in that area or on those premises, I find it is not a substantial detriment. And for those reasons, we are asking and requesting the board to allow the extension of that non-conforming use. Now, normally in a physical use of property, a building, a non-conforming use cannot be greater than 50% of the original use. Here we're talking about not a building, but actually a use. If you put it into percentages, this would not be 5% of what the use is currently that's allowed under the non-conforming statute. So we're looking to extend it by, again, allowing him to take, if he put in 40 pounds of product, he puts another 5 pounds in there. That's the extension we're looking for. And again, I would ask the board to consider that and accept it. I would call upon Mrs. Creedon, if you would please, the treasurer of the club, just to attest and verify to this board that they have taken a very serious look in guidance and oversight of how the operations ought to be running going forward with the club.
Hi, Teresa Creedon, Treasurer, Brockton Country Club.
Please speak right into the microphone.
All right. Teresa Creedon, Treasurer, Brockton Country Club. The board has taken a very active review and oversight of our food and beverage vendor. We do solicit, we do interview, we do meet periodically with our vendor. We are aware of the work that he's doing in our building and outside our building. We are aware of the rules of outside work. He has been instructed that at no time will people be allowed to come and pick up food from our club that are not members, that there will be no cooking other than for the benefit of the members. We have looked and set up systems to ensure the security at our club meets the issues that were brought towards us with permanently locking our gate each night. Locking our gate each night. We've updated the security in our parking lot with new lights. we're, I certify we know exactly what he's doing and when he's doing it.
Thank you.
Thank you.
With that, Mr. Chairman, if there are any questions, we'll be happy to respond.
Board members, any questions?
Attorney Nazarella, when was this, you said there was a change in the board, and after that change in the board, it was then made clear to the person who was running the commissary that they were to no longer be doing sales to the public, different things like that. When exactly did this occur?
Exactly, I can't tell you, because there had been a change in the board. The past president, Tom Burke, had resigned. Ms. Creedon stepped forward as the treasurer, and we've been monitoring within the last month, and also been monitoring the way it's been advertised, and we found that it was still being advertised to the public. That's been terminated with certain consequences if it were not to be terminated or to raise its head again. So there's not to be any non-members invited to the facility, the parking lot, or the building. There is not to be any food preparation on the premises, meaning the building and the grounds, for third parties, only for the club. And this has been narrowed down within the last several weeks.
Would Ms. Creedon have a date that may have occurred, or is there anything in writing to that effect?
No, I know I've been having ongoing discussions with her for the last couple of weeks, saying it has to stop and you can't do that activity. She's agreed on it, but has taken a forward step of monitoring it as well.
Okay.
So it's done. It says not to be any advertising at all. That would be a strict violation by the commissary against the club, and they would terminate the particular practitioner.
So I guess my next question is this then. I have multiple complaints here filed and cease and desist orders filed by not only Commissioner Plouffe but also the Chief of Inspectional Services in regards to this matter prior to that. I guess my question is, why weren't any of those cease and desist orders followed until this potential meeting that you state happened that is not recorded anywhere?
Well, I think there was a disconnect within the club because, again, there was a president who left. I don't know what I really can't tell how much monitoring or enforcement he did. Ms. Creedon is a former CPA, and from my limited experiences with her, she's a no-nonsense woman, and she says, I'm not going to put up, and the club's not going to put up with any disobedience of what these rules are. And as I stated in my presentation, I didn't have any disagreement with Mr. Plouffe's statements of what should be done and not done. So I can't explain the past offenses. I could offer the mea culpa, but saying going forward, and this is what we're talking about, and that's the reason we're here, going forward and seeking the extension is going to be very strictly construed and subject to any sanction if it is not strictly construed. But I can't explain what the past was.
And Ms. Creedon wasn't on the board prior to that. Would she have any insight as to what went on prior to this at all in regards to why these cease and desist orders were ignored?
No. I only met her a couple of weeks ago when she stepped forward, contacted me and said, I need to sit with you and straighten this out. And
okay.
That's where we are.
I have a copy of the contract here for services between the club and the client, the petitioner. And in this contract, it says, under Section 18, the club grants to Deegs Local Diner exclusive catering and beverage service rights to all club and outside functions, including member and non-member functions. So it sounds like he's got a contract that allows him to do whatever he wants to do down there, irregardless, I should say, of whatever conversations you may have had.
That's been revoked. And the reason it's been revoked, I had advised him that the current ordinances and laws, regulations, and orders or dictates from the building commissioner supersede the contract. You can't contract to do something which is not valid or illegal. So, Mr. Chairman, that has been stricken, and he cannot do anything with third parties and non-members.
Is there a current contract in place?
Not that I'm aware of. Well,
Would the treasurer know? If there's a current contract and if there's what?
Is there a superseding contract from the one that has been revoked, those terms in there?
At this point, no, that's our current contract. And when we wrote the contract, not knowing all of these rules, we were talking about things like charity golf tournaments, bereavements, those kinds of things, that it could be a sister of a member that comes down for a bereavement, that he's the exclusive caterer at our facility for those indoor events. Not that he would solicit events and bring them into our club, because our president had to approve every event at our club.
And as the treasurer, obviously you play one role here. Where is the rest of the board on this? I know you're watching it like a hawk, as you state, but are you the only member of the board that's doing that? Because that's concerning.
Not any longer. We have a board of 10 people. We're all volunteers. We all set up where our area of expertise is. Being the CPA, guess what? I've been the treasurer for years. No one else wants my job, frankly. We took on the food and beverage committee with the president and vice president, of which the president was monitoring and working with the city on various licenses through the years, so that was his area of concern. And this got away from him, along with other things happening in his life, so that he's withdrawn from the club, so other people are stepping up.
So there's currently a new president?
On November 18th, we had our annual meeting, and we have elected a new president who is very involved with this, is copied on everything I'm doing now, and we're all going to be part of the monitoring team.
And I can also, Chief, ensure and recommend that a new contract be written up within a week, which will address the issues that the chairman just raised, that we have superseding orders to comply with the law as opposed to what the contractual terms are. You can't contract to do something that's invalid. That's what that now is raising its head on. We're going to rectify that. Again, I'm not asking for, I think it's important that we don't make a decision that we're taking them to the woodshed, but rather that going forward, here's the way we're going to act, and subject to the sanctions if we violate that. But I want it to be clear to the board that it's been recognized, these past indiscretions, in going forward, they will not happen. This is going to be for club purpose only, not for any third parties.
And I completely understand what you're saying. I think the concern is, though, we have a list of multiple cease and desist orders that were completely ignored. And, I mean, I don't know these folks. I mean, you want to take people at their word, but there is a track record now of showing complete disregard for the building commissioner in his rule of law. And now all of a sudden we're supposed to say, okay, they're going to change because you're before the board looking for a variance. That's what I take deep concern with.
Yeah, but what does that mean? If there were the past errors, and here we are going forward looking we wouldn't be here if we were looking to do it the right way. So we have to go to zoning and get our permission. So I can't keep getting beat up over the past, and I can't explain the reasons why. Who was in charge, why they didn't do it, why they didn't cease or desist. Maybe they were told it was being a cease and desist and never did stop. I don't know. All I can talk about going forward where we are. And that's what I'm asking the board to vote on.
I completely understand that. Completely understand that. But you have to understand our trepidation in what has gone on. You're a bank robber, you're a bank robber. Leopard doesn't change their spots. I think that's a deeper concern here.
Yeah, but this is not a leopard.
Especially as a public safety official, that's a deep concern.
Excuse me?
Especially as a public safety official, that's a deep concern.
Well, what public safety is involved here?
Obviously, I mean, I have a number of, I have what I have in front of me. Like I said, this is fresh to me. I have complaints of unlocked gates and issues with vehicles. There were supposed to be gates that were locked by the proprietor. I have letters in here that talk about motorcycles in that area, unforeseen traffic. I mean, we have a place in the traffic commission. So I think I'm just explaining my concerns on that, because I have to have concerns about that. That, I mean, traffic concerns are an issue. Samuel Ave is about this big, width-wise. So,
Well, I don't know who generates that traffic, who the people were on the motorcycle, what it's got to do with anything. I'm just trying to keep it a
understood.
narrow lane here so we're not mixing,
And as am I.
you know? Yeah, okay.
It sounds like, so far what I've heard, is you are asking us to believe that you are telling us that there was indiscretions that went on in the past, and now those things will not be happening in the future.
Correct.
That's kind of what we're hearing here. That is not what is on this piece of paper tonight.
What piece of paper?
What you are looking for is to allow the use of a food truck on the premises, utilizing the club's commissary and selling its products to customers. That's what's
Club-
here tonight. That's the
Club-
hearing tonight.
No, club customers, not customers in general, not third-party customers. Club customers.
We could be very specific that in our decision, that anything that is made in that commissary stays within the confines of that club.
Exactly. I would encourage that.
Okay, so what I heard from you is what we're looking for is permission to put extra food in their refrigerator so that he can take that extra food, put it in his truck, and deliver it somewhere else. Isn't that what you said?
That's correct.
That's correct.
Okay, so my concern here is that we're on the verge of a commercial operation here, where if we allow a commercial operation with this food truck to operate out of this club, what happens when a second food truck shows up, or a third truck, or a fourth truck?
Well, Mr. Chairman, the food truck is not operating a business there. All it's doing is taking the food that's being stored in the refrigerator and taking it elsewhere.
Well, that's not what we are hearing, that this food was prepared, advertised where people could come and get a meal, take the meal, go home, eat the meal, take it off premises. It sounds like a restaurant was operating here for the general public. That may be what you're telling us isn't going to happen in the future, but that's what we're hearing, and that's kind of influencing what we're hearing here tonight.
Well, I don't think that's what I'm telling you now. I'm telling you that may have happened in the past. That's been frowned upon, and also that activity has been stated as terminated going forward.
So
It's not to be
probably
allowed.
the crux of this hearing should be to rectify any misunderstandings about what can be done and what can't be done at this location. And it appears as though, even from your discourse, that things have been happening down at that club that shouldn't have been happening there. You're telling us you got new people in charge, and it's not going to be happening in the future. Perhaps the decision of this board should be to make sure that it doesn't happen again in the future.
I agree with that, and what I'm, I guess, suggesting was there was perhaps not both eyes open by the prior individuals from the club that should have been monitoring it. And that's why I opened up by saying I don't disagree with the building inspector's, the contents of his letter as to what should be done and not done. Fully in agreement with that there shouldn't be running a third-party enterprise out of there. There shouldn't be cooking on the premises for third parties or non-members, and there should not be non-members coming to the premises for anything. And that's been understood both by the food truck operator and the club. Can't make it any clearer than that. I'm in total agreement with you about that.
Very good. Board members, any other questions? Everybody's going to close that portion of the hearing. I'll open up for public discussion. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone here that wants to speak in opposition? All right, please come forward. If there are a number of people that want to speak on the issue, the only thing I would ask is please do not keep reiterating issues that have already been brought forth.
Good evening, Mr. Chairman, members of the board. My name is Attorney Robert Galvin. I represent Edward Towig, trustee, 90 Samuel Avenue. I submitted a letter earlier today. I don't know whether the board has had a chance to see it. I have extra.
Saw the letter, but quite frankly, I haven't read it.
Okay. I'll summarize it, and I brought extra copies if anybody needs them, so just let me know. But in any event, my client has property that's a little bit further down Samuel Avenue from the entrance to the club. We're opposed to this request tonight because we understood that this was a request to sell, to basically establish a catering business that's going to operate out of the club using a food truck that's serving on this property and serving elsewhere. And we understood this was a request for a variance. I raised some initial issues with the advertisement and the agenda because the application indicates it was a request for a variance, but the advertisement suggests that it was a request to extend a non-conforming use. And I couldn't really reconcile that. Plus, I did understand that there was a problem with the identification of the district. It sounds like you've resolved that as a Scrivener's error.
We're looking at a variance tonight to allow this to take place, a C2 operation in R1B.
Okay.
That's how I'm looking at it.
And not as a special permit?
Nope.
Okay. So I guess, making a long story short, I heard no evidence on any of the statutory criteria or evidence under Section 2748 of the zoning ordinances that would qualify for a variance. In any event, I really couldn't follow the logic of the questions and the answers that you were just receiving. It sounds very clearly to me like they wanted to use only a portion of their refrigerator to help the gentleman that is an outside vendor that happens to cook food for the members of the club. If they're looking to use the portion of the refrigerator or freezer for the members of the club, they don't need anybody's permission to do that. What they're looking to do, and I think they've admitted it reluctantly amongst some circular answers, that they're looking to basically operate a catering business for third parties out of the club. And they want to have a food truck there. And that food truck is coming in and going out. It's been seen in the past in the parking lot selling food. It's going else into other locations selling food. And I heard there's all of a sudden a change in management, but if you looked, as I did, on Facebook just prior to Thanksgiving, you will see just less than 2 weeks ago, they had an advertisement on Mr. Deeg's website on Facebook, and he was encouraging people that had purchased Thanksgiving dinners to come and pick them up at the club. These were not for members. This was within the time frame where apparently they had new responsible owners, and they haven't even got a contract that says this. This gentleman is clearly selling food as a caterer, not for the people that are members, not for the people that are guests at this club during golf or country club relating events. He's selling food elsewhere to non-members. He wants to use the club as a commissary, which is nothing other than a place where he can cook and prepare meals for delivery to third persons elsewhere. It's completely not allowed. It wouldn't be allowed whether you looked at it as a special permit, and you wouldn't be allowed if it was a variance for the following reasons. Clearly, this is a residential district. You're not allowed to alter or extend a non-conforming use in this manner. It's basically adding another use. This is a country club. No one would dispute that they can golf, tennis, swim, whatever they want to do at an ordinary country club. No one would dispute that they have the right to have food for their members and the people that are patronizing the club, or drinks if they have an alcoholic beverage licenses. But what's going on here is, because they use an outside vendor to cook their food, and the outside vendor wants the ability to sell food elsewhere, they're making their club available to this vendor, who's not even part of the club, to sell food elsewhere. And that's not something that the club should be asking for a special permit on, because it's not even functionally a club use. This is Mr. Deeg and his business that he wants to move in there, and operating a restaurant or catering business with a food truck out of this place is substantially more detrimental to the neighborhood. And there are a myriad of complaints that have been caused by this. And if it's stopped, it's just stopped right after Thanksgiving. We had a private detective go out, observe the whole thing, have it all on video, happy to give it to you, so you can see exactly what was going on here at Thanksgiving just less than 2 weeks ago. If this is a variance case, you have to establish there's something unique about the soil shape and topography of the lot that's unique to this lot that justifies this property owner, Brockton Country Club, getting a use variance. There is no mention of the word soil shape or topography of this lot. As a matter of fact, I don't think it's conceivable that there'd be any type of unique soil shape or topography of this lot that would justify you allowing them to engage in this type of a use from the country club. And if there's any hardship to them, it's Mr. Deeg's hardship. It's not hardship to the club. They're operating, when they operate without this, functionally as a normal club would. When they add Mr. Deeg's use, they're adding a catering business that's going to be in and out of there, selling to third parties, and that's just as clear as day. They haven't established anything, they haven't even mentioned the elements of the variance that relate to derogation from the spirit and intent of the bylaws. But, you know, Brockton is very fortunate. Someone a long time ago in 1965 decided that if you're going to have an accessory use, which I don't know whether they're trying to argue that either, but that all has to be done from the inside of the club. This has got an outside and inside presence. The food truck is in and out. It's obvious to people that live in the neighborhood that there's another business going on here. And we're asking you all to deny the requested relief, particularly if it's a variance. But even if it was under a special permit standard, I would submit that they have not met the case, that this is not substantially more detrimental to the neighborhood. Thank you.
Thank you.
Hi, my name is Edward Tuig, represented by Attorney Galvin.
Could you speak up? I didn't get it.
Hi, my name is Edward Tuig, represented by Attorney Galvin, who just heard from. I don't have anything further to add. He, I think, summarized the situation quite succinctly. I did just want to read into the record a communication that I received earlier today from a fellow neighbor, Mr. Paul Landerholm, who unfortunately couldn't attend tonight. I, Paul Landerholm, hereby state my opposition to the proposed variance. The zoning in our neighborhood strictly prohibits these types of businesses in our area as they do not belong. I strongly believe this will lead to more strain on our infrastructure and more traffic on our already busy Copeland Street section. Reckless Uber Eats drivers ripping through our neighborhood is all we're going to get from this, as if we don't have enough. To grant this variance could also lead to more restaurant-style businesses popping up in places they don't belong. As a case in point, the White Plains Country Club down the street from Brockton Country Club petitioned for the same type of variance in 2006, and they were denied based on the same premise. And last time I checked, Brockton Country Club was a prominent golf course, not a commissary. And so thank you. I appreciate the board's time on this matter.
Thank you.
Good evening, ladies and gentlemen.
Good evening.
Tom and Karen Rogers, 29 Samuel Ave.
29?
Yes, we are direct abutters to the country club. We're surrounded by their property on two property lines.
Is your house the one that's just before the parking lot?
Yes.
Got it. Thank you.
Yes.
Yes. We have a letter here we'll leave with you. It pretty much summarizes the points that the two
Oh,
previous
back.
gentlemen had made based on the events of the past 3 years. We've been through the cease and desists and everything else that was mentioned earlier.
And they still did take out for Thanksgiving.
2
just
weeks
so you
ago,
know.
they were giving out dinners.
We
There's
have
no
proof.
question about it.
So they did not
We
discontinue.
would like to ask the club, on behalf of the neighborhood, to find another way if this is being brought as a hardship, because the food business isn't going to make up their hardship.
Do you want me to read the letter?
Yes. No, we don't have to read the letter. Collectively, we prefer the club find a better solution to the current situation. This club has been in the neighborhood for a long time. We have no issue with them serving food to their members. We take a big issue with a restaurant and a potential fleet of food trucks
And
coming
things-
into the neighborhood.
And things are going on, and he is cooking there.
It's a very
We have
small
proof.
street. It gets even smaller with all the traffic for the club. If you have restaurants and takeout coming in, it's going to be a public safety issue for the people that use the street to walk their dogs, their kids. It's a really quiet neighborhood, and we'd like to keep it that way. And we hope you'll agree with our points. Thank you for listening to us tonight.
Thank you.
Should we give this to you, or?
You have something you want to add, or you're done?
I'd like to leave this with you, if that's okay?
What is it?
Good evening. My name is David O'Shaughnessy. I live at 429 Copeland Street. I'm just to the east of the Brockton Country Club's parking lot. I understand that the club has a kitchen and they've always had somebody in there for club functions, for the guys to come in and have a beer and a sandwich after a round of golf. That's great. Now, they needed somebody in there, and they've got this gentleman. He's got a food truck that parks next to the maintenance building of the club, which is 100 feet from my bedroom window. And I constantly have to look at this truck because it's always parked there. I've asked them several times to have them park it somewhere else. For a while it disappeared, now all of a sudden it's back. The club has always had functions, had food up there for the members and for the guests and for club functions. I think that's fine. But digs on the go, people coming in to pick up food, order food from his truck and from the clubhouse is not something we need in our neighborhood. We're in a residential neighborhood. It's a nice, quiet neighborhood, nice little golf course. Never had any issues with it. I just don't think that this is going to turn into anything that's going to be good for our neighborhood. That's all I have to say. Thank you.
Thank you. Is there anyone else who wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official who wants to be heard on the issue? Councilor.
Good evening. My name is Susan Nicastro. I represent Ward 4 on the Brockton City Council. I've done so for the past 7 years. I'm also a resident of Samuel Avenue. I guess you'd say I'm wearing several hats as I stand here. I understand that the ZBA has received at least 1 or 2 or 3 other letters from residents as well as other councilors. Are you going to be reading those into the record, Mr. Chair?
I will.
Okay, I just want to make sure I was asked to ask that. So I take an oath to uphold the ordinances of the city of Brockton as well as the laws of the state and the federal government. It's a heavy burden, constantly doing research. 265 Samuel Avenue has been in an R1B zone since R1B zones were created. I had the opportunity this afternoon, just to make sure you had some pertinent information, to send you a portion of the GIS map that shows where 265 Samuel Avenue is and the densely populated neighborhood located all around it. I live across the street from the side of the building. I've got a bird's eye view when I make my cup of tea every morning of what's going on in the kitchen area. So the entire neighborhood is residential. The club is in a residential zone. I've lived there 34 years. There are people who have lived on the street longer and on Copeland Street, of course. And you know, isn't a neighborhood a community all in itself? Isn't it a microorganism all in itself? We all know what each other are doing, at least as we come and go and in our yards and stuff. The two families who have stood up and spoken to you this evening, they love their yards. In fact, I have a yard. They have gardens. They spend a lot of time raising vegetables and beautiful flowers and trees. So they're outside a lot. They hear and see a lot of what's happening with the country club and with the street that perhaps others in the neighborhood would miss. So when they tell you that they've been dealing with this for a long time, they really mean it. They've been living with it. I will tell you, I don't want to dispute or disagree with what's been said about a new regime and all that kind of stuff. But on Friday, Saturday, and Sunday, the food truck guy was there working. I know that there was a food truck event on Saturday in Taunton, and I watched him as he loaded his truck, pulling alongside the kitchen, left during the hours of the food truck event, and then came back afterwards and unloaded. So this is continuing. This is going on. I have no reason to believe anything is going to change. They seem to have cleaned it up nicely and put a pretty bow on it for you this evening to get what they want, but I just have no confidence that that's what's going to happen. And that's a concern because this is a violation of our laws. And this has been going on. I first found out about this in April, And that's April 24th, I think, is the date of the first cease and desist that you received by email. And during all these months since April of 2024, there have been numerous meetings that the mayor got involved in, trying to find some kind of a compromise, that Mr. Plouffe was involved in, and Mr. Forte, who works with him. And people said whatever they wanted. They made representations. Oh, I'm just selling takeout during the winter months when things are so lean. If you look, there's a current takeout menu that applies to this week and into next week. I mean, that's just what's going on. Anything you want to hear will be said to appease you, but that's not what happens. What happens is whatever is wanted to happen, okay? I believe the location, size, and character of the proposed use, we're not even quite sure what that is. Is it a special permit? Is it a variance? Is it a commissary? Is it a food truck? We're not quite sure what that is between the notices and the application and what was said this evening. But whatever that proposed use is, it's not in harmony with an R1B zone or with this neighborhood, this long-standing established neighborhood. The proposed use is detrimental to the existing neighborhood. You heard some of that this evening. The proposed use is inconsistent with the layout of the city, as it's been laid out all these many years later. It's a commercial use in a residential zone. And if you choose to go down this path tonight, for whatever reason, this will open the floodgates. We will have all kinds of disruptions and disorganization in our zoning and in the layout of our city, and our neighborhoods essentially will be destroyed, because that's what I fear happening in my neighborhood. This use change will not preserve community values. It will just cement the fact that anything goes, because that's what's been experienced for the last nearly a year. Anything goes. And I will tell you what is even more disappointing for me. I've lived on the street for 34 years. The country club and its leadership have been my neighbors for all these years. And for a long time, that leadership was pretty much in line with the neighborhood. And there were many members of the neighborhood on the board and in ownership and as members. But that's not what's happening here. That's not how it is. I would say to you that in these months since April, it's like the country club didn't care what the neighbors thought. They just didn't care. Let him do whatever he wants, because we can have a cold beer and a hot burger when we get off the links. That's very disappointing. I really dislike saying that. Finally, the documents don't protect. What's asked for tonight, it doesn't protect the surrounding neighborhood. It hangs it out to dry. And so for all these reasons, because I can't take off my hat as both a city councilor and a resident, I ask you not to approve this. Thank you very much.
Thank you. Is there any other elected official who wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone that has a question relative to the testimony that has been given tonight?
Mr. Chairman, if I may, just make a half a minute.
I will give you 30 seconds.
That's all I wanted. That's more than I wanted. I just want the board to be clear from what I had heard was well beyond the realm in borderlines of reasonable statements. This is not going to be the Sodom and Gomorrah and the downfall of the whole city of Brockton. What we are asking is very limited, that he use the kitchen to store the same food as the food that he's going to be cooking for the club. No cooking or any activity will be done for any third party or any non-member of the club. So all their concerns they were talking about may be legitimate, but it's got nothing to do going forward. And to remind the board, this is not a board of retribution for what he may have done wrong in the past. That's why we're here now, going forward.
Okay, we hear what you're saying, Councilor. I think we've...
Yeah, one last thing, Mr. That's important, because there was also talk about fellow brother council, the standards for variance. If you look at the application, it also says relief from a extension of a non-conforming use pursuant to 27-39. That's what we're looking for, to extend a non-conforming use, nothing more, nothing less.
Very good, thank you. I have 2 letters that have been sent to the board in opposition. I will summarize them. This is from an abutter at 15 Samuel Avenue, lifelong resident of Brockton. It was erected close to the rear of our property, which is the storage shed at the time. At the time, the club agreed to lock the parking lot entrance gate to keep people out of the secluded area between the shed and the houses on Samuel Avenue and Copeland Street, and to the landscape the area to create a buffer. In the past year, several changes have taken place in the use of the club's property that is disturbing, and I felt I have unsafe in my house several times. The gate is often left unlocked. Traffic and litter have increased due to the food vendor who is running a side business selling takeout food to the public at a private club, the Brockton Country Club. I object to having this business so close to my home in this residential neighborhood, and I hope that you do not grant a variance. Due to work commitments, I am unable to attend tonight. This one here is from Councilor Farwell. Please accept this communication response to an agenda item on tonight's agenda. Please be advised I do not have any prior relationship, positive or negative, with either the country club or the person operating the food business. They are unknown to me. However, as a city councilor, I take an oath to uphold the laws of Massachusetts. I support that zoning ordinance and regulation and oppose the granting of any variance. To do otherwise would set a precedent in our city that other R1B zoning areas would be ripe for commercial businesses, which detract from the residential neighbor of a neighborhood. That is happening now with the food truck business operating at the Brockton Club. Please protect the interests of this neighborhood and its residents, some of whom are retired from teaching and wish only to live in peace and quiet. Thank you for your consideration. So those were 2 letters that have come in opposition. Another letter has been submitted. However, the petitioner or the neighbor who spoke tonight spoke exactly what that letter says. If there is no one that has any question relative to the testimony that's been given, I will close that portion of the hearing. That will conclude the public hearing. I will now open it up for deliberations among the board members. Board members.
Well, this is certainly a unique case where the golf club it's unique. We have, 3 golf courses in the city. I seem to think this could be an opportunity to clean up some of this mess with restrictions, but I do see it both ways, so I'm interested to see what other members have to say.
I personally, I mean, if we reflect on the case we had last week on Rockland Drive, last month on Rockland Drive, they were operating a commercial business in a residential zone. It's just, it puts the people, the folks that live in these residential communities in a difficult spot. I think we have to be very cognizant of not just this case, but any other cases moving forward in regard to that. And setting any type of precedent is my concerns, obviously.
No, I think we're all on the same page, the residents, even Brockton Country Club. I don't think anybody wants to see a commercial business there. So I think what they're asking for is just the storage. I don't think they're asking for too much. But we're not here to approve a commercial business, right?
Well, it all depends upon what the motion is going to be. It would appear to me, from the testimony that you heard tonight, they want to allow some type of what we may call a commercial operation at that location. Whether it's, I'll wait till you get through.
I mean, if we can put some stipulations just to keep it just to storage, that's all they're requesting.
I think if they're not serving third party, the truck would serve as a delivery truck anyhow, which they would probably use anyway.
Right.
Or if they had, just say another vendor there.
I think we have to be careful splitting hairs here. We're talking about a golf course that has a commissary, that now we're allowing that party that is doing the cooking to do storage there, but we're looking to now to manipulate what storage is versus anything else. So that's my concern on with stipulations on this. a lot of that will be out of sight, out of mind. You know what I mean? We won't, so I don't know. I get concerned about a slippery slope. That's just my concern with that.
I think it's going to be very difficult to try to say that we can limit the food storage in the refrigerator to 40 pounds of meat. How could anybody here ever regulate such a thing? I think the case that's before us is a private golf course that had a commissary that catered to the members of that club who used the commissary inside the club for years and years and years and apparently caused no problem. What has developed now is a third party has come with what we're describing as a food truck. That third party is using the commissary of the golf course to operate his food truck. Now, in my mind, that is now turning into a commercial operation at the golf club, which is totally different than cooking food in a commissary for the members of the club. So if a member of the club wants to go in and get a hamburger and a beer, have at it. That's fine. Me, as a member of the general public, not a member of the club, I have no right to go to Samuel Avenue, go in there and have a beer and a burger right off the street. That would be like walking into a restaurant. If one of the members down there wanted to invite me in and sit at a table and have a burger and a beer with that member, I don't see we got a problem with that. I think what was faced with tonight, from the testimony that we've heard, is that whatever happened down there got out of hand, and they're telling us tonight they got new representation down there, they got new leadership, and all this is going to stop. There is nothing that prohibits them from going astray again and then having to come back before us again. I am concerned that if we allow the food truck to operate out of that parking lot of that golf course, that today we could have one food truck. Tomorrow we could have 2 food trucks. Next week we could have 3 food trucks. What is to prevent the operator of the commissary to invite other catering services to bring their trucks down there where he could supply them with food? I mean, this can just blow up out of hand here. And I just want to be very parochial in how I'm going to vote on this thing, is that the golf club is a private club. It's for those members of that club. And if they have a commissary where they want to cook food for the members of the club, have at it. I hope they got a common victuals license for that food, and I hope that they have a liquor license to serve liquor down there. Not my responsibility. That would be other agencies that will look into that. My concern is I don't want a third party to show up down there and make a deal, which we had. They say now this thing is null and void, but if you read it, it basically says that he can cook food, put it in his truck, and go do whatever he wants with it. And I think that is what's caused all the trouble down there. So I think if we're going to make a motion here, if somebody wants to make a motion, I think we've got to be very careful in what we're looking to do here. And what I see in the application is they are asking to allow the use of a food truck on the premises, utilizing the club's commissary and selling its products to customers. That's what they're asking to do, even though tonight they're telling us they don't want to do that. We want to look at perhaps in a motion to prohibit the club resources to sell to the general public, advertising for sale to the general public at 265 Samuel Avenue, offering the private club function room for retail to anyone that is not a member of the club, and using the Brockton Country Club as a formal address for any business-related food trucks. There shall not be any member purchases of food or beverage for takeout. Additionally, depending upon how this vote goes, but I'm concerned about the prepared food for commercial catering, distribution, and/or sales as a public restaurant type of operation, or advertised food to take out to the general public. The commissary is to be operated for the benefit of the club members only, with no food sales to the general public. Now, that's a long dissertation, but I think if you want to comment on what I just said, that's how I'm looking at how a motion probably should come forward that kind of covers, I think, what the concerns are with this club.
Well, I think the motion should be made for exactly what they're asking for, to allow the use of food truck on the premises, utilizing the club's commissary and selling its products to the customers. That's what they're actually asking for here, correct?
That's what they're asking for, and I think what I did is kind of embellish what I read is
The
to what
contract.
they're looking to do. So,
With the stipulations that you've highlighted, I'd motion to approve.
I'll second.
okay, motion has been made and seconded with the dissertation that we just gave relative to the motion. I would ask the clerk to please call the roll.
Mr. Lanez.
Yes.
Chief Nardelli.
No.
Mr. Sweeney.
Yes.
Ms. Greenberry.
No.
Chair Galligan.
No.
Mr. Chair, that's 2 in the affirmative, 3 in the negative.
The vote is 2 in the affirmative, 3 in the negative. The petition is denied. All right, the next petition is 2467, the petition of Vincent Aiello, care of Attorney Phil Mazzarella, 1063 North Main Street, Brockton, Mass., seeking relief for a variance from Section 27.9 and 2748.1, subsection 1, subsection 2, to construct a single-family home in an R1C zone located at Plot 24 Gladstone Street. The property is situated between 22 Gladstone Street and 36 Gladstone Street.
Good evening, Mr. Chairman, members of the board. Again, Attorney Philip Nazrella representing Mr. Aiello. I know that when I spoke to him a few days ago, he had taken ill. I don't think he's not here, and I'm not expecting him to come, so with your permission, I'll proceed without him together with Mr. Faria, the engineer. Mr. Aiello is interested in developing a parcel of land on 22 Gladstone Street, which is a pre-existing lot. If you note, that street has several lots, many lots of similar size and shape or area size as the one in question. This particular lot is probably, when you talk about odd-shaped lots for purposes of variance, this one is the ideal one because I've never seen a lot so odd-shaped. Scott, could you just kind of draw your finger around the lot, please? Right. I've tried to determine how that lot came to be, the whole sector, and how its formation. I have no idea. But in any event, the lot is a separate lot again. It has never merged with the other lots. It has an existing barn on it, which is the intent to take down the barn and put up a house. That lot's been in existence since 1925 when they had horses and carriages, so we don't expect that barn's going to be used for any future purpose of similar nature. It's a residential area. There are houses on all of the other lots. The highest and best use of that piece of property would be to take down that barn and put up a house. As a side note, I heard a report last week that the Federal Housing Authority in Washington indicated that we have 4 million homes short of what's really needed. And in Massachusetts, there are about 400,000 homes short of what's needed. That's about 15%, 13 or 14% of the national average. So without question, that would be the ideal spot and the highest and best use to put a house. It meets all of the zoning requirements except for a rear yard setback. It has side yard, front line, and it complies as a non-conforming lot in all other respects. So I see no reason why a residential structure should not be allowed to go forward and be placed in that area. We ask permission of the board to do that, and if there are any other questions, I'd be happy to answer that. And before I turn to questioning, I will note one other item. A matter came before the Massachusetts Appeals Court 2014 relative to this section 48, section 6, that said a variance for a prior non-conforming use to introduce a new non-conforming use to a pre-existing area is an appropriate process in order to do what we want to do. So we're taking an existing non-conforming use and looking to put in a new non-conforming use, basically switching out a barn for a house. If there are any questions, please feel free to shoot away.
Board members, any questions?
What is the, sorry.
Yeah, go ahead.
Thank you, Mr. Chair. What type of construction is that house again?
The proposed house?
Proposed
It would
house.
be a single-family home.
A colonial? Okay.
Four-bedroom colonial.
Sideways?
Yes.
Okay. Front door,
Front door facing Gladstone.
the street?
Yeah.
Okay.
Kind of traditional, old-style colonial aesthetic.
Okay.
And he's also well aware, I made him well aware, Mr. Ferry made him well aware, that the city's preference is not to have cars in the front, a driveway, garage, and so it would be in keeping with the same context of the surrounding area and with what the ideals of building and zoning are in these times.
Okay.
By the way, Mr. Aiello, the owner of Arbor Construction's a master builder. He's built dozens and dozens and dozens of residential structures as well as commercial properties. He's a guy that knows what he's doing.
And what's
You
the,
had somebody down there?
what did you list as the hardship?
Well, actually, it's a non-conforming use, but the hardship would be if we want to go on the variance route, the odd shape of the lot. It's not a square, it's not a rectangle, it looks like a boomerang. I mean, I've never seen a lot that size, the way it's juxtaposed in there. So that clearly is the hardship.
Are you referring to this lot as a boomerang-looking lot?
Well, I wouldn't say boomerang, but it's
Well, you did, and I think you're referring to Plot 25.
correct. I'm talking about the whole area around it and the lot within it, yes. It's just the way it was constructed is a very odd way. But I think the more important part is that it meets similarly all of the other lots in the area. It's the same size and shape, and it's basically the same, so it's not as though we're asking for extraordinary relief from something that's odd from everything else in the area. It's consistent with what's in the neighborhood. So I asked the board not only to look at that, to bring in their collective common sense that this would be the best and ideal use of the property. If we were going to look just at the code and say, these are the requirements, do you meet them and not meet them, I wouldn't have to be here. The reason for the board is to see if we can vary what the Mr. Plouffe does that. He looks at what the law states, says you either have it or you don't have it. You come before the board, you ask the board to vary it because it makes sense to be consistent with what we already have there. And that's what I'm asking the board to
So
do.
your testimony tonight has got to convince this board that there is something odd about this piece of property.
Well, there's something unique about it. Unique according to what the 2024, 2025 regulations state as to what a lot should have.
There has been numerous requests for buildability of this lot over the years, going back 15 years ago, and every one of them has been negative. We also have a ruling from the law office that looked into this in 2011, this very same lot, and the law office determined that this is not a buildable lot.
Do they happen to say why?
Separate mets and bounds. If you look at the deed, I got a copy of the deed here, and the deed describes the current house that's there and this lot all on one deed, all under one set of mets and bounds. So my question to you is, if you're going to try to develop parcel number 24, do you have a deed for parcel 24?
I do not have a deed presently with me, but I do have the plans showing it as a distinct and separate lot.
We go by the latest deed, as you know, and the deed, this one is 2003. It encompasses Plot 23 and 24 all under one deed, and those two lots have merged together. So as you know, this board has no authority to separate those lots to allow you to put a house on there unless there is something that delineates that lot. And right now, 23 and 24 are all one lot.
All right, well, I understand what the chairman's saying, and I also understand I could go to the planning board and get it separated. But I also suggest to the board that a deed is not necessarily controlling. It's one element of the evidence that would be put forth. It's basically what the intent of the parties are. So sometimes you have a scrivener that could be a paralegal or a lawyer that doesn't do real estate and write up the whole thing as one meets and bounds instead of separating it. That happens all the time. The intent, by looking at the way it's laid out and being on a plan as showing as separate and distinct, to me would give evidence and information that that was intended to be a separate lot. You can accept that as the way you want. I'm looking to get the highest and best use of that property. If I have to go the long route around, go before planning board, ask them to separate it, then come back, that only brings me back to where I am now. The board has the authority to declare it as a separate lot.
Okay, I disagree. And the plans that were submitted, which are these plans right here, there's no question in my mind this is a raised ranch. And the raised ranch front entrance faces the house on the south side of Gladstone Street. It does not face the street. I don't know where this colonial came from, but this is it right here. This is a raised ranch.
Yeah, the owner indicated it was intended to be a colonial. And you can put that in the stipulation that it has to be a colonial.
We can't stipulate it has to be a colonial if we don't have any plans in front of us. How can we vote on something that we don't even see?
Well, you can do that. This is not the architectural board. I can put together and represent to you it will be a colonial.
I realize that. I am
Okay.
just expressing you my concern, and I need an answer to this question right here that appears as though this diagram that has been submitted with the evidence tonight is a raised ranch. A raised ranch has an entrance that's on the front of the house, that in this case, the front of the house will face the house next door. And the
That's
board
why
has
I would
looked on
confirm.
disfavor on those.
Yeah, I understand that. I'm confirming what Mr. Ferry said. It's going to be a colonial.
Okay, board members, any other questions? Everybody's good? I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone here that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official in the room that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone in the room that has a question relative to the testimony that has been given tonight? Seeing none, I'm going to close that portion of the hearing. That will conclude the public discussion. I will now open it up for deliberation by board members. Board members.
I mean, I do see the possibility of this being, non-detrimental in fitting into the neighborhood. However, technically, I don't know if there's a Mets and bounds issue, or was that the original rebuttal on the previous attempts to develop?
Yes, the ruling was that the lots have been combined. They are together as one lot with one set of Mets and bounds. Very similar to what we saw up in Carlin Roads. Similar situation to that.
In many ways, it does seem more suiting for the planning board to divide that.
Motion to grant?
Second.
Motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lanus? Mr. Lanus? Oh.
Yes.
Chief Nadelli?
No.
Mr. Sweeney?
No.
Ms. Greenberry?
Yes.
Chair Galligan?
No.
Mr. Chair, that's 2 in the affirmative, 3 in the negative.
The vote is 2 in the affirmative, 3 in the negative. The petition as presented is denied.
Thank you.
The next petition, 2468, petition of Joseph Diderot Hierarch Design Collaborative, 36 Bromfield, Suite 208, Boston, Mass., for a variance seeking relief from Section 2740 to build a 6-unit residential building in a C2 zone located at 310 North Main Street.
Mr. Chairman, thank you very much. Members of the board, my name is Jim Burke. I'm an attorney at law with offices at 48 North Pearl Street, Brockton, Massachusetts. I didn't actually file this application, and I know the principal had to be out of the country, so I'm left carrying the burden. The property is very unique. I think probably there's great familiarity with it with some of the members of the board. It originally housed an 18-unit apartment building that was built in 1900. It burned in 2021, and as a result, it has lapsed as it relates to a non-conforming use. So the applicant needs to come before you today to get permission to get a variance for the proposal of the 6-unit structure that's there. Why I say it's unique, it's a very small piece of property, 55 feet of frontage, 6,000 square feet. It is surrounded by an L-shaped parcel that the applicant, by the way, has tried to make arrangements for parking, which has been unsuccessful, but it was an aggressive effort in an attempt. It is also impacted negatively by an easement on its southerly side that predates the existence of the zoning ordinance here in Brockton. The net effect is you had a residential utilization for over 100 years. It does not set up well as a commercial utilization of property. The type of structure and building that you would put on the property to do a commercial use is greatly limited by the size of the parcel, the width of the parcel. The utilization by any of the commercial uses that are allowed in a C2 zone, C1, C2 zone, would have substantially more of a parking impact than it would as a residential utilization. I think that the architect in its presentation has done an exceptionally good job in trying to make a presentation of a facility that can fit into the narrowness, the unique size of the property, and create something that's brought back to a utilization that is consistent with what it was for 100 years. It's also in a neighboring neighborhood now that is encroaching with residential development. I had the benefit of this board granting a variance not too far away down the street, and it's a transitioning to a mixture of residential and commercial uses. I think that the 6 units is a good utilization of the property. I think that you have the ability to grant the hardship based on the size of the property, the restrictiveness of the lot as it relates to the ability to build a representative commercial structure on it that could house any use that's authorized under a C2 zone. And I think that's essentially it, and I'm more than happy to try to answer any questions.
Board members, any questions?
Real quick, what are you listing as the hardship? Just the size of the lot?
It's the shape of the lot and the size of the lot, the narrowness of the lot, how it impacts the ability to reutilize it with a structure.
And was that 12? I'm trying to think. I had the fire. I think it was 12 apartments prior, correct?
18.
18. All right. I was off by a few. Yeah, it was big. Very windy night.
Under 2740, it gives the petitioner the opportunity to come back to restore a building that was destroyed by fire, even though it's in now a zone where it would not normally be allowed. So if it's destroyed more than 60%, or if it's destroyed totally, he can come back and we can make a determination whether it's an appropriate use.
I have nothing else.
And Chief, I think you can testify that the building is gone.
It was a very stormy night.
Any other questions for board members? Seeing none, I'll close that portion of the hearing. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone in the room that has a question relative to the testimony that has been given tonight? Seeing none, I'll close that portion of the hearing. That concludes the public discussion on the issue. I'll now open it up for board members for deliberation. Board members.
I think they're putting a house back there that was there before that looks exactly going to be...
I can't hear you.
I think they're putting a house back there that's going to be very similar to the house that was prior there. It's actually, although 18 units before, we're down to 6. I don't see the parking being an issue because of the fact that we're actually reducing it by, 12 units. I don't see, plus, with, according to the attorney too, with the stuff that's going to be built coming up North Main Street, this is prime for, commuter rail living and such as well. So I think it fits with the neighborhood. It's going to be basically the same house rebuilt, just less units.
I would think based on the size of the lot, to develop that as a commercial use is going to be very difficult.
Won't happen.
And it did have a prior use as residential, and it would appear, the old one was 4 stories, this one is 3.
Mm-hmm.
So the impact on the neighborhood is far less than what the other one was.
And I would just add to that, Mr. Chair, that it's a better use considering the traffic issues that I'm seeing in front of Al's grocery store. So that bottlenecks too. This being a residential use is much better than a commercial use.
Make a motion to grant.
Second.
So the motion is to allow them to build a 3-story, 6-unit apartment building. That's what we're voting on. Motion has been made and seconded. Will the clerk please call the roll?
Ms. Delanus?
Yes.
Chief Nardelli?
Yes.
Mr. Sweeney?
Yes.
Ms. Greenberry?
Yes.
Chair Galligan?
Yes.
Mr. Chair, that's 5 in the affirmative, 0 in the negative.
Vote is 5 in the affirmative, none in the negative. The petition is granted.
I thank the board for its time.
The next petition, 2469, a petition of DDO New England LLC, 3845 Stockton Hill Road, Kingman, Arizona, for a special permit seeking relief from Section 2729, subsection 3 and G, and Section 2737 and Section 2749 for a drive-through service for a restaurant in a C2 zone located 715 Crescent Street. Good evening.
Good evening, Mr. Chairman, members of the board. Attorney Michael Spillane with Marioni, Shaughnessy, and Udy in Quincy. I represent the applicant here. They are looking to construct a Taco Bell restaurant at the old Bank of America building at Crescent Plaza, which is where Home Depot is, if anybody's not familiar with it. The actual use of the building as a restaurant is a by right use under the zoning bylaw. The only relief that we seek and is needed is a special permit for the drive-through. There's an existing drive-through already there and has been used previously by the bank. We are in a C2 zone, and excuse me. So it's consistent with other uses in the area. Right across the street, there's a Popeye's Fried Chicken that has a drive-through. There's a McDonald's right next door with a drive-through. There's a Northeastern Savings Bank that has a drive-through. The access to and from the Taco Bell is going to be off the drive into Crescent Plaza. It's on the right-hand side. It's its own pad. We are not doing any construction to the building other than interior and making it nicer looking. There's not going to be a tear down. There's not going to be, additional construction. We don't have a parking issue. There are, I believe, 22 spaces shown on our plan. There are 9 required under the zoning bylaw. And right now, I believe there's, 3 lanes? 3 lanes. So we're going to reduce that. There's only going to be a single lane on the drive-through. I don't want to take up too much time, so, it seems fairly straightforward. It is, like I said, it's consistent with the neighborhood, it's consistent with other uses in the area, and it's an appropriate use. This is the applicant's the same owner that owns the Taco Bell on Belmont Street. They will be hiring anywhere from 45 to 55 local employees, so it's another added benefit to the city. Unfortunately, without the drive-through, though, it just doesn't work for their model. So,
Mr. Chair, if I may.
Yes, go ahead.
So you mentioned that the owner's going to be the same as the one on Belmont Street.
Mm-hmm.
Is that going to look identical to this? Are they going to make that identical?
so it's not quite identical, I don't believe. Correct? Yeah.
So the difference is, I guess, maybe is what I want to hear.
Okay, so I have some elevation plans. I'm happy to distribute them to the members of the board. This is basically the east elevation. This is Nicole Duquette from Greenman, Peterson. The engineer.
I'll take those.
Yeah, I got it, so you can pass them down.
So it would be, fairly consistent with their construction types. It's not going to be quite as condensed as the one on Belmont Street. And it will be front-facing on Crescent Street.
Walk-in as well, correct?
This is the Crescent Street side here. Yes, walk-in.
Walk-in, not just the drive-through.
Correct, correct.
Down with lighting, not to disturb. Because of it being on the end, I get concerned about the woods and the neighbors, but.
Yeah, I think they're fairly far away.
Yeah.
But yes. Yep.
Just in case, you never know.
So on the same theme of lighting, the Belmont Street is very articulate in terms of lighting. Will that be the case on this?
I missed what you said.
Will the same architectural lighting, not just your doorways and your entryways, but the sconces on the building itself, on the one on Belmont Street, is that something we're going to see?
This is Mark Raymond, from DDO New England. He can probably answer some specific questions on the construction itself.
So there will be exterior lighting on the outside of the building sconces. They will match the current brand standard, which reimages every 5 years. So the current model lighting is an up-down lighting that is strictly on the building, and it just goes up into the parapet and down directly to the ground. So there will be sconces. The lot lighting will be directional into the lot, everything projected into our pad.
The one on Belmont Street looks very nice, so that was why I'm asking.
Okay.
So just so I understand it, there's not what we call box lighting on the side that just throws light out everywhere. It's going to be downward lighting.
Correct, sir.
Okay. What's the situation with signage on this thing?
Nicole.
Sign expert.
Yes.
Nicole Duquette from Greenman Peterson, or also GPI for short. It's easier to write. The sign, there's a freestanding sign that's in front of the site. It currently shows Bank of America. So DDO Foods does plan on refacing that sign and using that. As far as the signage on the building goes, we will work with the current sign standards and mimic what's there today as far as square footage.
Any LED signs?
Are we going to change that to an LED sign?
So all of the signage themselves, they are LED anodes inside, diodes inside, but they're still flex-faced, and the channel sets on the building as well as the two bell.
I'm sorry, I couldn't hear what you said. Just come closer to the...
I'm sorry.
Yeah.
Yeah, so the signage themselves is the actual LED diodes, but it's all covered and encased in the sign faces themselves. And there is a purple wash LED that goes down, it's under the parapet and it projects down on top of here to here. It does not go lower than that. It just accents that, but you do not see it because it's up under this little like trim piece that the whole strip is like this big.
So the Taco Bell sign is what we'd see right there?
Yes, correct.
A freestanding sign on Crescent Street?
Correct.
That sign is currently there?
Correct.
That sign needs to be at least 10 feet back from the sidewalk. Is it 10 feet back from the sidewalk?
Not sure. I mean, it was the sign that Bank of America had been using. I don't know if we have a measurement on our plan for where that sign currently exists, but
All right, so since they're out of there, that sign becomes abandoned. So we have a regulation in the city, the sign has to be 10 feet back from the sidewalk. Is that going to be a problem for you? With your landscape area, is there plenty of room in there to get the sign in?
We can push it back.
Okay, so
Yeah, we
the
can-
sign will be 10 feet back. The plans you submitted tonight show us green space and plantings along Crescent Street, which I think is a big improvement. Did the board see that?
so the plan that you're seeing here tonight is an improvement off of what we submitted with our application. We added some more landscaping area. It's in color. It looks a little bit nicer than what we had available when we submitted the application. Yeah, go ahead.
So just to add to that, we did meet with Rob May before we came here to make sure that he was on board with this too, to get the staff's recommendations. And he did have us add a couple of landscaped islands here that he thought would benefit the site along the back. We were already planning on adding the landscaping towards the entrance drive, but he did have us add the landscaping area on the next to the dumpster and exiting the drive-through site there. So this has an increase. We're cutting those areas of pavement. Those are pavement today, will be green space in the future.
Is there any reason why you picked that location for a dumpster right out on the street?
Because it was the only place, I don't particularly like putting them like that, but it's the only place on the lot that I could put it that could be picked up.
So if you kept it on the same side of the building and pushed it to the back of the lot, wouldn't that, in other words, whatever's on that right-hand side, those parking places will move closer to Crescent Street and the dumpster put out where that green space is back in the corner. Wouldn't that make sense?
It would make sense if I didn't have to have about 50 feet clearance in front of the dumpster for the dumpster to maneuver. That's what I've been told by waste management companies, is that to keep 50 feet clear from the dumpster opening to anything that would impact its maneuvering.
So they can back the truck up? Yeah,
So that they
and
can
that,
move it.
that can't happen in that back corner?
It can't, unless we get rid of all those parking spaces there in the back.
Well, Mr. Chair, if I may,
Well, what happens if the gates to the dumpster face to the left instead of towards the street? There's more than 50 feet over there. You see what I'm saying?
So we would have to remove all the parking spaces along that side in order for that to happen.
If you want, I don't want to go out in the weeds on this, but I'm just kind of disappointed that we see a dumpster sitting out in the street. So what I'm saying is, if the 50-foot access to the dumpster was to the left as you look at this, in other words, if you looked at it from right here, if that was the entrance to the dumpster. Yeah, sure. If that was the entrance to the dumpster right there, that's more than 50 feet. All I'm saying is, what would happen if you moved the dumpster back there and shifted this slightly this way? Put the dumpster there with the gates that face that way, not that way.
This is green space right here. we'd have to get rid of all that green space.
Okay, so you got an answer for it. All right.
That doesn't happen often. I'll just tell you, that doesn't happen often. Good job.
So if you guys can figure out how to move that dumpster, I think it would benefit everybody, because it wouldn't be the big feature sitting on your front
I
yard.
understand.
What I'm saying?
We're trying to mask it, and I realize it's a dumpster in front of the site, and like I said,
I
I
would be
don't
willing to
typically
give up
like
some
that.
green space to get that dumpster out in the back.
Yeah, okay.
Mr. Chair, I just want to highlight the fact that this is not going to see planning, so it's, because it doesn't trigger a significant change in the structure, it's not going to see planning.
715 Crescent Street does not have to go to planning.
So this is
Straight up
where
from
we're
there.
at, right here with it.
So could we, we're just discussing this now, but could we let them know we would really like to see the dumpster towards the back of the property instead of sitting out front? And that would be okay if they gave up some green space in order to move that dumpster out there? I'm just throwing it out here, so.
I mean, I wouldn't have a problem with it. I mean, but
It's not the end of the world, but honestly, if they're going to spend all this money to make this building look very nice in that location, that's the end of my discussion.
Well, if I could make one suggestion to the original change that the chair had suggested to the top right, what if you took those parking spots and put them closer to the queue line, leaving that outside, leaving all that an open 50-foot stretch, and you move your parking towards the queue? You just slide the parking to the left, and then you have your straight shot getting that dumpster.
You know what?
I'm really disappointed in the dumpster, to be honest with you.
Everybody will end up parking parallel along that outside.
I mean, that's one of our major arteries, you know?
Well, anyway, we're off base. Let's get back on base again. Any other questions from board members? We're good. The overhead that is currently there for the bank, is that coming down?
So,
The drive-through overhead?
so yes, we'd be reducing that down just to the one lane. So it's, right now it covers 3 lanes. We're going to cut that back, keeping the same roof line over that existing 1 lane and opening that space up.
So you're going to have 1 drive-through lane,
Correct.
whereas a lot of your competitors are now looking for 2 drive-through lanes, yeah.
They are. We could not make 2 fit on this site, and we have the option with the brand to go 1 or 2, and we do run these plans by the brand, and yeah, they did approve this layout with the stacking and everything.
All right, board members, you all set? Everybody's good? I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone here that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official in the room that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone in the room that has a question relative to the testimony that has been given tonight? Seeing none, I'll close that portion of the hearing. That closes the public discussion. I'll now open it up for board members for deliberation. Board members.
I don't have anything.
No, I think overall it's a good use for it. I think you know what my concern is, so I'll stop beating that horse. But if you can make a change, please. You're not going to see planning, so motion to approve.
Second?
There are no stipulations that we talked about at all on this. I think the green space is a good improvement over what was originally planned, so. All right. Motion has been made and seconded to grant the petition as presented. Will the clerk please call the roll?
Mr. Lantis,
Yes.
Chief Nadelli,
Yes.
Mr. Sweeney,
Yes.
Ms. Greenberry,
Yes.
Chair Galligan.
Yes.
Mr. Chair, that's 5 in the affirmative, 0 in the negative.
The vote is 5 in the affirmative, none in the negative. The petition is granted.
Thank you very much.
Thank you.
We'll do our
very
best.
much.
Thank
We
you.
will.
Yeah, we'll take another look at it.
All right.
Is it 484 Pleasant Street now? Oh, it is. Okay.
All right, the next petition is 2470, the petition of David and Lori Rezovitz, care of John E. McCluskey, 1325 Belmont Street, Brockton, Mass., for a variance seeking relief from Article 6, Section 2732 and 2710 to modify a previous zoning approval and change the location of 4 new two-bedroom apartment units to be constructed outside of the flood zone in a C5 zone located at 484 Pleasant Street.
Good evening, Mr. Chairman, members of the board, Mr. Clerk, Attorney John McCluskey representing David and Lori Rezovitz, Scott Farrier with us with the plan. I'm going to call this a modification of a variance that occurred back in 2021. We came before this board. The history of this property is that it was a commercial, residential, I'm not quite sure, legal property over the years. The prior owner came to me relative to his being shut down for various violations. There were several, what I would say would be illegal apartments. At the end of the day, David and Lori Rezovitz bought this property from my client, and we came before this board and asking for a variance to allow for a total of 10 apartment units. At the time, there were existing, at least in theory, 6 apartment units. Those would be right along here. This is the existing structure. And when David and Lori bought the property, at the time when we came before the board, we got a variance to allow them to reconstruct these units and then to add, do you have that old plan?
I do not have it.
Okay.
No.
But it's in the application to add 4 newly constructed apartments here, which, as you see this line, would have been in the flood zone. And we received a letter from an engineer stating that this would not compromise the flood zone situation. Since that time, back in 2021, the Rezovitzes have totally reconstructed the existing building consisting of 6 units and actually put in about $600,000 to improve the property. Now, in trying to complete it and do the final 4 units, they realized that it probably wouldn't be in their best interest to build 4 units here in the floodplain. So they proposed to the board tonight to modify this old variance and to move the 4 units over to here. I'm assuming you've seen the proposed building, which basically would keep going away from this. Would look like this, and there'd be 4 units here, 1, 2, 3, and 4. So 1 and 2 on the first floor, and 3 and 4 on the second floor. 2-bedroom apartments with living room, dining, kitchen, 1 full bath for the 2 bedrooms. And this will be I think it's going to be a prefab, correct? Yes. This will be a prefab, so it'll just be delivered onto the property. So basically what we're simply asking is to be allowed to move what was allowed here, which they actually could still build under the existing variance. They could still build these 4. Their project, as you know, many of these projects go on for years and years and years now because we went through COVID and there's been extensive renovations to this property. I believe they're all rented out.
They are.
And all with long-term leases. David and Laurie have worked hard. As you probably know, we're law partners, and I think he spends more time down on Pleasant Street working on this property than up in the law office. But in any event, I go back to the comment that Mr. Sweeney made years ago about lighting, and we've accomplished that, and the lighting is as requested. All the build-out, the sprinkler system, everything has been done, and there's been a lot of money put into this property. So we'd like to move this allowed for unit apartment building over to here. This adjacent property is residential property. This is in a C5 zone, and there's a 20-foot setback requirement here. We'd ask for a variance to do 10 and a half feet. They could do 20, but it would make this property work a lot better if we were allowed a variance for a 10 and a half foot setback for this new building. And in looking at this residential property to the east, there's some storage of vehicles in here, but pretty much back here, as I've just recently looked at it, it's pretty much wooded, so I don't think that'd be an issue relative to the relief from the setback. The hardship goes back to the original application. The board found that this property was of unusual shape, size, topography. Down in here, the Salisbury Brook runs right through here. So you've got the floodplain in here, and that makes it of unusual topography and soil conditions. Certainly, this is one of the, I believe it's 61,000 square feet, so it's one of the largest lots in the area. And I think carrying forward the hardship from the earlier case and just seeking this minor modification, I think, would fit within the hardship requirements and requests. So, anything else? No. I think that's it.
Board members, questions?
So how many total units are over there now?
6.
6?
And you approved 10.
But it hasn't been built, correct?
The 10 have not, the additional 4 have not been built out.
And this would be a separate, basically a separate dwelling is what you're getting at. Separating away
separate
from
dwelling.
the current.
This one would have been connected, the old one would have been connected to this. And it's really, push it over 30 feet, and there you have the new one.
Understand.
And we have 23 parking spaces. We only need 20.
We've had a few cases before you folks lately with flood zone issues. And, putting a building in the flood zone, although it's doable and permissible, there's a lot of hoops to jump through. Doing it this way, it gets the building entirely out of the flood zone, puts the parking area in the flood zone, which isn't as big a deal. If there's a foot of water in the parking lot, you're just going to get your shoes wet stepping out of your car. It's a lot easier permitting through conservation having a parking lot in the flood zone than it is a building. So that's the biggest reason to flip-flop the building and the parking from the previous proposal.
What's the width of, so I'm just thinking fire apparatus, ambulances, things of that nature, coming up there now from the back end.
Yep.
It goes right into that basically like parking lot area, correct?
Yes.
What's the space between the parking spaces and that building?
It's 24 feet.
24 feet wide?
Yep.
Okay.
Yep, the spaces are, I believe they're 10 by 18 spaces, and then the 24-foot travel way.
Okay.
So you still have the opportunity to build what was previously approved, correct? Right. So assuming you got an approval on this, you'd also have the right to build the other part?
We have the right to build 10 units. And I think, although that's a good question, there's no intent to build. In fact, we'd stipulate that we would waive the additional 4, which were approved by the board here.
So you had no problem with that stipulation?
None whatsoever. David and Laurie don't want to have more than 10 units. Yeah. Good point. I didn't think of that.
So why can't they put 6 units in the barn?
We have 6 units, all occupied.
And how many in the house out front?
No, there's 6, if I may. There's 2 existing, hi everyone, David Resovitz, thank you. There's 2 buildings that are attached at the corner, each with 3 existing units, so there's 6 total. So what Lori and I are proposing to do is essentially have building 1 with 3 units, building 2 with 3 units, and building 3 to be constructed with 4 units. All fully sprinklered, there's fire alarms in there. 100%, we did 100% renovation to the existing 6 units. Took a lot longer and cost a lot more than we thought. So we figured, after spending all that time there, we realized that the property slopes a little bit from east to west. We could put the 4 units that had been previously allowed up to a higher and drier side and move and essentially flip block it with the parking, as was stated. So
the barn has 3 units in it.
All right, let me get my numbers right. The original house out front has how many apartments in it?
3.
3. Now, it says in the barn, existing 6-unit residential building.
That's for the entire building, Chairman Daley. The entire existing building is 6 units.
Meaning the building and the barn connected together.
The building in front, the barn, it's connected, so it's
Understood.
technically one building.
So 6 up front, 4 on the other building that's going to be built, potentially.
Right. Yeah, they're right here, from here to here. And that's what's on the ground now. There are 6 units.
So what we granted the last time was, or the previous to that, we granted 6 units. Then you came back and we amended that and we wrote a new variance to allow you to go from 6 to 10.
Yes.
The understanding at the time was those 10 units were dispersed between the house out front and the barn out back. Correct?
No, not sure about that. You allowed us to build 4 additional new units, new construction, out the back. We weren't going to put all 10 in that existing structure. You allowed us to build into the floodplain, which is right here.
So there would have been 3 buildings no matter what. There's 3 buildings now, but one of them is separated off.
Right.
To the other side of the property.
Yeah, the only change is we're moving from here, new construction,
to the other side.
to here, new construction.
I think what the chairman may, if I may, I think what the chairman might be referring to is prior to my purchase, Attorney Nazarella, representing prior owner David Cavallo, came before you for permission to convert it to the existing buildings from mixed use to 6 residential units. And that wasn't that long, that was only a couple years previous to the purchase. So that was that action that came before your board. And then Attorney McCluskey came before you in 2021 where you approved the additional 4 units to go from 6 to 10. So just if that clarifies.
Separated over more buildings, though.
Yeah, it was always going to be,
yeah.
You had previously approved the 3rd building attached in the back, and tonight we are asking for permission to move it higher and drier detached also in the back.
So basically, we're talking 10 units overall. You're telling us that you just want to relocate 4 of those to get them out of the floodplain?
Yes, just as previously approved, 10 units overall. We just want to move it across.
So the barn you're telling us originally on the second time you came back here, there was an addition going to go on the back of the barn.
Right.
4 units.
That's the additional 4 units.
You got it here? Got it, okay. I see what you're doing.
I think that was back in like January 22 or something. It was
Yeah,
a couple of years
so-
ago.
What the building inspector is showing is an addition on the back of the barn that was approved, but the addition was never built because now it's sitting in the flood zone. So you want to take those 4 units that were approved and just move them out of the flood zone.
Exactly.
Right. I believe I submitted as part, up in the portal. This portal is very interesting. But it's in the portal. The plan that was approved 3 years ago shows the attached additional 4 units.
I think what I'm concerned about is I don't want the density or the number of apartments to increase in this thing. This is a C5, and I remember distinctly the problem with this property was it could not be developed as C5, and it became abandoned, and it was an eyesore to the neighborhood.
It was condemned.
And it was the feeling of many that if this was converted to residential, it would be a far better use than letting it sit where it is. I have watched this thing as it has been developed, and it looks like all the things that we talked about were done.
Right.
And it looks very presentable. The addition on the back was the 4 apartments, and that's what's slipping me. And
Which have not been built. We just want to move them across.
I got it. So actually, we're making the size of the buildings on the property are going to get bigger than what than originally was. However, the number of apartments involved doesn't change.
No, and in fact, I think that the size of the units that were proposed here is larger than what is now proposed. So it's I think, is that correct? We're down a little bit?
Yeah, the square footage of the building that's going to be moved higher out of the floodplain is a little bit smaller than the 4 additional units that you previously approved. Lori and I were trying to get some 3-bedroom units in there, but it was just it was problematic. So what we did is we found a building that is similar in style. We re-sided the existing building in a nice pale yellow so we can match this one in another colonial pale yellow with white trim and just make it look like a nice condo complex.
So do you have an apartment right now in the basement of the barn?
There is one, yes, technically, there is one unit, unit 6 of 6, is in the back of the barn building. It's a 2-bedroom unit.
When I went up there and looked at it, it appears as though there is a door with a handicap ramp that comes out.
That's correct.
South side of that building, which is in the basement of the barn.
That's correct.
So in the barn, is the layout with the 3 apartments, the basement, floor 1 and floor 2?
Yes. There are another nice thing about the existing 6 is that they all have their own private entrance. As far as the 3 units in the barn, there are 2 doors in the front of the barn, apartment 4 and apartment 5. Those are the 2 3-bedroom apartments in this entire building. All the other existing ones and new ones will be 2-bedroom apartments. In the 5 out of 6 of the apartments enter from the front of those 2 buildings. The 6th one uniquely has because of the grade down towards the Salisbury River, it has a walkout and slider, and there's a 2-bedroom apartment in there. Lori and I had a older woman who had been looking for a handicap accessible apartment for years and finally found one, and we moved her in there. And sadly, she passed away, so we recently reletted it to a new tenant. But it does have that kind of handicap access still there.
So that apartment is not subject to flooding?
No. The flood zone just nicks the corner of the building, and you're correct that that's where, if the small amount of the building that's in the flood zone is in that apartment. We haven't had any water issues there. Prior owner Cavallo owned it for a few decades, told me that there wasn't any water issues there. My inspector didn't find any water damage there. I still have to pay flood insurance for the entire building because of that corner. But, you know, fortunately, the Salisbury hasn't swelled all the way up that way.
So just to end my concern here, I notice on the board out front, you've got 10 mailboxes.
Yes, that's right. And 10 services, because I don't know why my contractor put 10 mailboxes. I think it was after the board had allowed the original 10 units. I also had my electrician put 10 services there just because it was more economical to do so.
Okay, so that led me to believe that there are already 10 apartments in the two buildings.
I can see that. The only thing I can say for that, if you notice, there's only 6 names on those 10 mailboxes.
I can't read that close.
Yeah.
All right, I have no more questions.
You know, I drove through there recently, I saw the 10 boxes, I said, I know he's going to bring that up.
Wouldn't you be disappointed? Board members, any other questions?
We wanted them all to match, so if, you know, we bought them all at the same time, we know they don't match.
Nothing.
Board members are good? Okay, we're going to close that portion of the hearing. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official in the room that wants to be heard relative to the issue presented tonight? Seeing none, I'll close that portion of the hearing. Is there anyone here that has a question relative to the testimony that has been given? Seeing none, I'll close that portion of the hearing. That concludes the public discussion. And before I open it up to the board members, I have a note here that 484 Pleasant Street, if approved, would be required to pass through site plan review. Board members.
I think I understand the project a little bit better now than I did looking at it prior to coming in tonight. I think it's good. Obviously, they're taking a more bigger approach to getting it out of the flood zone. And, you know, we've had run into issues, you know, before with that. So I think it's nice. I think, obviously, you drive by there now compared to what it was 2 years ago, and it is a completely different house. So I thank you for that. I think it's a good project. I think it'll lend to the area. Obviously, the units are filled. He's not going to be stuck with these. So
they satisfy their hardship?
I would say so. Mm-hmm. Yes, because of the topography with the flood zone. Mm-hmm. You know, I believe that. You know.
Well, if there's no further discussion,
I'll make
the
a
chair
motion.
would entertain a motion.
Motion approved.
Second?
Motion has been made and seconded to approve. Will the clerk please call the roll?
Mr. Landis?
Yes.
Chief Nardelli?
Yes.
Mr. Sweeney?
Yes.
Ms. Greenberry?
Yes.
Chair Galligan?
Yes.
Mr. Chair, 5 in the affirmative, 0 in the negative.
Thank you.
Vote is 5 in the affirmative, none in the negative. The petition as presented is granted.
Thank you very much. Nice to see you tonight.
Good luck.
Good luck. The next petition, 2471, the petition of Claude Pierre, 126 South Leaden Street, Brockton, Mass., for a variance seeking relief from Section 2725 to allow a two-family dwelling in an existing residential structure in an R1C zone located at 126 South Leaden Street.
Mr. Chairman, members of the Zoning Board, my name is Jim Burke. I'm attorney at law with offices at 48 North Pearl Street in Brockton. I have the pleasure of representing Claude Pierre. This is kind of an unfortunate situation. Claude purchased the property in 2010. The property was built in 1890. It's actually a lovely piece of property in a nice old section of Brockton. When it was sold to him, it was representative. I presented that in the materials I submitted to the Zoning Board as a two-family home. In fact, it is not a legal two-family home, and that's what brings us here today, because the building department at some point in time indicated to Mr. Pierre that it was not conforming and he needed to apply to the Zoning Board of Appeals. It has been functioning as a two-family home since 2004. There's a definite language problem, and I can understand how the situation arose when he purchased the property in terms of communication with a broker and the representations that were made. Scott went ahead and designed a plan, and we have created a layout for you of a floor plan. In fact, Mr. Pierre lives in the second level. The first level is a better rental unit, and he uses that as a rental unit, and he lives in the second level. There is ample parking based on what Scott has presented for us, and I'd suggest by way of a hardship, we all know that the accessory dwelling unit law is going to affect probably, I think, sometime in February. Under that act, this would be a prime piece of property to qualify for that, except that the statute restricts it to 900 feet, and we're just around 1,200 feet. I think the intent is exactly the same of the statute, and that is to provide good, usable, affordable housing and creating accessible dwelling units within a community like Brockton. In fact, de facto, that's what it's been doing since 2004. So it's a real unfortunate situation. Mr. Pierre is a hardworking man with a family, works 2 jobs, and he's taken this very seriously. Scott, if you want to do the layout?
Sure. Currently, there's an existing driveway on the right-hand side of the house. So knowing the board's desire to have enough parking for a 2-family, we decided to extend the existing parking, use the backyard, and come up with 6 parking spaces in the back for the 2 units. So we do lose the green space in the backyard, but it's really the only choice and the only placement we had for the parking that we typically try to show the board. So that's, as far as the site goes, that's the only significant change to the site, will be the addition of the parking area.
What does it have for parking now? If it's been used as a 2-family, where have they been parking?
Just a skinny single-width driveway.
So they stack them in there then?
Yes. And I'm sure park on the street.
So this has been used for how many years as a 2-family?
2004.
And we don't know of any problems that this has created relative to being a 2-family since then?
Well, I think the fact that we don't know is a good indication that there haven't been, and that's a good thing.
So if this is approved, one of the stipulations that we will put on this, that the 2-family dwelling must conform to all current building codes and laws relative to 2-family dwellings through the building inspector. So you have no problem with that, obviously. 2 exits, whatever.
There are 2 exits. I don't think it's perfect, as you can understand from an older structure, but there are 2 means of ingress and egress.
I guess my concern is that this building just comes up to code as if it were being built as a new 2-family, and I'm sure the building inspector understands that things have got to make sure, we're concerned about the safety of people in the building.
Understood. Yeah. Understood. It would, and I anticipate, require some flexibility from the building department's perspective in working with the older structure.
Are we looking to potentially have to make the second means of egress an outside stairway?
I hope not.
The only reason is because you have to come back now for the outside stairway.
Yeah, I think the way it's currently laid out is I guess the secondary exit is on the back side of the house.
Yep.
Main entrance on the front, so I don't think there's a need for it. I think you can get upstairs and downstairs from both entrances.
Okay.
The front and the side.
The front as well?
Right.
Okay.
So you just brought up a good point that relatively new exterior stairways require a special permit from this board. Yeah. So Board members, any other questions? None? We're good? I'm going to close that portion of the hearing. I'll open it up for public discussion. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official in the room that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone in the room that has a question relative to the testimony that has been given? Seeing none, I'll close that portion of the hearing. That concludes the public discussion. I'll now open up for deliberation among board members. Board members.
I personally think to the fact that this hasn't been an issue, they've been parking all along, they're actually going to increase their parking. Obviously, the gentleman that bought this was in a tough spot. I mean, obviously, we can't, that's not our issue to deal with, but I don't think the fact that there's been any problems with this residence and the parking, there's been no parking issues that we're aware of, because it probably would have been brought to our attention here tonight by the neighbors. I think it's a good project that, you know, as long as obviously they're going to adhere to the building codes and make sure we have two means of egress and things of that nature, I think, you know, I think it's kind of pretty straightforward.
I would agree.
I agree as well.
I think it's not detrimental, and I think it's an opportunity to, again, what the chief said, get it up to code, so.
Yeah, I think that's one of the things too. I think we can clean a lot of things up with this. You know, if there were any issues, that'll be taken care of, which is
Well, that was
even
my
better.
concern, that somebody could have illegally made this into a two-family years ago, and we don't know what they did in there. So all I'm trying to do is open the door for the building inspector to make sure that it's...
Absolutely, and we know they're all over the city that we come across all the time. So this right now, we're able to put it in a position where now it has to conform, and it'll work out better than what it is currently.
Right.
I'll make a motion to grant.
Second.
With the stipulation that...
With the stipulation up to the building codes, yep, correct.
Yeah, okay. Will the clerk please call the roll?
Mr. Landis.
Yes.
Chief Nadelli.
Yes.
Mr. Sweeney.
Yes.
Ms. Greenberry.
Yes.
Chair Galligan.
Yes.
Mr. Chair, 5 in the affirmative, 0 in the negative.
Vote is 5 in the affirmative, none in the negative. The petition is presented and is granted.
Thank the board for its time.
Good luck. Attorney Burke, just as a point of information, you may want to check to see if that correct address is South Leaden Street.
You know, if you look on the assessors, it says Leaden Street.
It does, huh? We always...
If you Google it, there is no Leaden.
Yeah, but it
It
says,
was going to send me to Boston. It's the only
That's
Leaden
correct.
Street.
It's like West Pleasant Street. There's no West Pleasant, is there?
So there is no Leaden Street, but in fact, the street sign says Leaden Street. It's north because you had, it was blocked off today. There was utility work. So it's Leaden Street. Across the intersection is North Leaden.
Yeah, interesting. We always knew it as South Leaden and North Leaden, so. Very good. Next petition, 2472, the petition of A&E Real Estate Investments, Liberty Street, Unit A, Brockton, Mass. For a variance, seeking relief under Section 2725 to be allowed to renovate and expand an existing structure into a three-family residence with parking that is less non-conforming in an R1C zone located at 412 Center Street.
Mr. Chairman, members of the zoning board, my name is Jim Burke. I'm attorney at law with offices at 48 North Pearl Street in Brockton. I have the pleasure of representing Mr. Mendez and Mr. Fernandez, two hardworking professionals who also invest in real estate. I preliminarily have to tell you that there is a bit of confusion because we are not asking for a three-family conversion. We're asking for a two-family conversion. That's less impactful in terms of zoning, and I don't think it presents a problem for you legally in proceeding. It's has less of a negative impact on the residential community than as was publicized. But if I may, this specific property is, and I looked at the assessor's records. In fact, I called John O'Donnell to just get clarification. It's, I think it's one level up from dilapidated is what the designation was. So what we're looking to do, if you take a look at the proposal before you, is really create a new professional, attractive structure that's in, it's a C2 zone, but it's a sea of residential uses. It's about 2 buildings away from East Junior High School. It's surrounded by a majority of multifamily structures. The way that Scott has designed it, he's designed it so it's becoming less of a non-conforming structure in terms of front setback and in terms of side setback. So, in fact, it's improving the existing condition on a structure, again, that was built approximately 1900. The net effect of allowing the utilization will be a substantial visual improvement in the east side of Brockton, and it will blend well with the surrounding community. It is a pre-existing non-conforming use for sure, the hardship relating to the narrowness of the lot and the uniqueness of the dilapidated non-conforming structure in the site that makes any conforming residential uses unrealistic, which are conditions especially affecting the parcel. So essentially what we're saying is it really isn't worth the investment to bring it back to code in its present condition. And the 2-family house makes it economically feasible to give you this very attractive improvement in terms of the facade of Crescent Street. And Scott, anything else you want to?
Just similar to the previous one, an existing driveway on the side of the building. We're extending to these 6 parking spaces for the 2 units. And as Attorney Burke said, by pushing the building back, we conform with the current zoning, but in addition to that, we get a little bit of a green space in the front yard. So we're kind of using up the backyard, but at least we're creating a green space in the front along the street.
Mr. Chair, if I may, are there any occupants in that building right now?
Are there what?
It's vacant?
No, it's vacant.
Okay.
So can I just go to your pictures that you gave us? One of them definitely looks like a 3-decker. Like it looks like it's a 3-family. If you can answer, just because of the confusion, because we're here talking.
That was the confusion.
Just if you can give your name to the clerk and step right up to the mic.
Name's Adam Armendez. I'm a managed member of V&A, Real Estate Investments. Yes, that is the confusion. I think that's why it was confused here. We both looked at our bank accounts as we coming up because we're not building a 3-family. So it is a 3-decker. It does have a loft-style second floor. So there are bedrooms on the 3rd level. So it's a loft-style second floor and a 3-bedroom on the 1st floor.
Okay, so just so I get this, there's a 1st floor, single-story, 1 apartment.
Yes.
The 2nd floor
Is a 2-story.
So that's why those windows are up high to give window light to the actual loft area. Then that's what you're getting at.
Most of the new 2-families that have been built in Brockton, most of them, the owner-occupied unit is the 2nd floor because there is a 3rd floor loft with a bigger bedroom up there.
Yeah.
So most of the ones that you've seen in the last 5 years built, they have that 3rd.
Is it open to the 2nd floor, that loft area?
Yes, it is.
So it's that's not enclosed up there. It's like a balcony to look over into, say, the kitchen, the living room, whatever the case may be.
Oh, no, it is enclosed. There is stairway to go up to the 2nd level. So if you look on the proposed plan, you can see that there's inside stairway to go to a 3-bedroom, 1 bath.
But no kitchen, no kitchen up there or anything else?
Absolutely not.
2 kitchens in the building completely?
One in the 1st floor, one in the 2nd. That's it.
Okay.
So was there an existing kitchen? Because I was looking at the existing map. Was it an illegal 2-bedroom? I mean,
yes. So when we acquired the property, it was presented to us as a 2-family. The assessor's office had it as a 2-family. We did a legal determination to ensure that it was a legal 2-family, and the building inspector came back and said, no, it was never legally transformed. There is 2 meters at the property, so that's why we thought it was a 2-family, but before we pulled the permit, we wanted to ensure that first before we move forward.
Are there, like, now, so let me ask you this, what about the services coming in, and are there 2 electric services?
There's 2 electric service, 100 amps each, yes.
And 2 furnaces?
No, 1 furnace and 1 electric up top, and then there's 2 kitchens though, as well.
Not that this makes any indication into what you're going to do. Do you plan on changing that heating, or is that going to stay?
Yes, we do
Okay.
plan on changing the heat into forced hot air inside units.
Okay. 2 gas services?
2 gas services, correct.
Really?
There's currently 1 there now.
So although it wasn't a 2-family, all the utilities aimed towards it was a 2-family?
That's why we had to do the legal determination before we
Understood.
pulled the permit,
Okay.
because, we didn't want to get denied, and it was never legally a
Understood.
2-family, so.
All right,
Yeah,
interesting.
it was odd to us too, so.
Yeah, okay, thank you.
Yep, no problem.
Now, do you know how long it's been a two-family?
I believe since from what the owner we bought it from, he bought it in 2002. So he said since 2002, it's been a 2-family. So I could, prior to that, if I look at the assessors, it's since 1947 on the assessors for the city, but I don't know how long it goes back from there.
Okay.
What are your plans for the original foundation that this house sits on right now?
So the original foundation, there'll be some of it that will be used, but there'll be new foundation built. So basically, that whole house is a tear down.
So the whole house is a tear down?
Correct.
What is the original foundation, stone?
Stone, yes.
And you're going to use part of the stone foundation?
Well, depending on what the foundation team tells us, they're smarter than I am, so they'll be able to tell me what legally we can do with the building department.
All right, so the plans that you show us, this thing to me looks like what I'm going to call a 3-decker.
Correct.
It's 3 stories with a roof, and it's not flat. This is a big building.
Yes, sir.
And it shows on the plans that I got here, 3 separate apartments.
Well, I mean, I could make it a 3 separate apartment. If you guys want to grant me that, we'd be more than happy to go back to the architectural team and tell them to build put sprinkler system in it, but it is a 2-family that we're seeking.
Okay. I will just tell you that my concern is this is built for 3 families.
Okay.
You could easily tell us that there's only 2 going in there, but at some point, this could easily turn into a 3-family. And it's...
Not in our watch, but don't know what the
The
two
plot
people
that
will
it
do.
sits
but-
on is way too small for a 3-family.
Yes, sir.
It doesn't fit or look like any of the houses in that immediate neighborhood right there. I'm just concerned that the plans that you're talking about don't really match in my mind to what I'm looking at tonight, so.
Okay.
All right. Board members, any other questions? Everybody's good? I'm going to close that portion of the hearing. I'll now open it up for public discussion. Is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any official that wants to be heard on the issue?
If I can interject, I went over this in detail with Jeff Thompson, and he authorized me to indicate that he supports the project.
Seeing no public officials here, other than what has just been expressed by the attorney, I'll close that portion of the hearing. Is there anyone here that has a question relative to the testimony that has been given tonight? Seeing none, I'll close that portion of the hearing. That concludes the public discussion. I'll now open it up for deliberation among the board members.
I think it's a good project. I'm familiar with the construction type. Coincidentally, in another city, I'm selling the exact same construction style, so I'm familiar with that, the loft style on the 2nd floor. So I think it brings up an eyesore. That's my opinion.
I mean, it looks more than a loft style than that. It looks like
Well, it goes
huge.
It goes into the contour, I believe. So it does downgrade a little bit.
Yeah, it does look like it's a 3-family, or it could be converted in the future to a 3-family.
I made a note here that I counted 8 bedrooms in here. I'm just very concerned with the size of the building and the size of the lot. I don't disagree, the place really probably should be taken down and something else built there. I just don't feel as though this particular building is the building that would fit on that lot. There is no question to me that this is a large, three-story wood frame building. Call it what you want, but it has the opportunity to dwarf into something down the road that we may not be happy with. So, that's my opinion. I just think it's a very large building for the size of that lot and the number of bedrooms. When you figure what we're getting to the point now where there's almost a car per bedroom. And I just think that this is pretty big.
Motion to grant.
Second.
All right, the motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lenis.
No.
Chief Nadelli.
No.
Mr. Sweeney.
Yes.
Ms. Greenberry.
No.
Chair Galligan.
No.
Mr. Chair, that's 1 in the affirmative, 4 in the negative.
The vote is 1 in the affirmative, 4 in the negative. The petition as presented is denied.
Thank the board for its time.
Just in reference, as a means of communication here, we did have some abutters that had sent opposition. You've got copies. I failed to read those into. I don't think it makes a difference at this point.
Got them. Read them.
Yep. All right, the next petition is of Railroad Construction Company, 7577 Grove Street, Paterson, New Jersey, for a variance seeking relief under Section 2729 and 2757 to be allowed to occupy and store material and equipment in conjunction with its construction operation at 1854 Main Street without the need for asphaltic or Portland cement paving in a C2 zone located at 1824 Main Street. Just for the edification of the board, both 73 and 74 are side by side at the location, and the way it is presented here, we got the yard before we got the building. So we'll look at each one of them individually, but I just want you to look at it as all the same location.
Mr. Chairman, with the zoning board's permission, my name is Jim Burke. I'm attorney at law with the offices at 48 North Pearl Street in Brockton. I'm here with Mark Schmidt, who is a representative of a railroad construction company. This is a good news story for the city of Brockton. Railroad construction is not a small outfit. It actually builds the rails for trains. It has a large contract with the MBTA. It is up and down the East Coast. It has 300 employees. It's an ESOP, by the way, so it's a employee-owned enterprise that's been in business for 96 years. They are leaders in the industry. They now have an extremely large contract going on with Amtrak. They are looking and they are expanding because of the size of the contracts to come into the New England area with a greater presence. What they essentially need is a office with laydown area for the materials that they will need as part of their work. They will not be conducting work in the yard. They'll be storing the materials of the yard and then going to the individual sites. The reason this is two applications is because the owner of the property holds it in two different entities. One is a trust and one is individually, I believe. So as a result, we're required to go ahead and make two different applications. The property is under agreement, and they would like to proceed and move forward with it. It currently received a variance. This is the parcel with the building on it, which is the southernmost parcel that's involved. The one directly to the north is now vacant. I believe in the past it represented a furniture business, and that has been torn down. And it is currently being utilized under a variance for the repair and sale of heavy equipment. You can see the materials sticking out as you go down. The building is really unique in terms of the northernmost portion. It takes up majority of the space. It is a C2 zone. It is extremely difficult to convert that structure into a reasonable C2 use. I think the board already reached that determination in granting the prior variance. There is an easement that bisects the vacant parcel and the parcel with the structure. There is ample parking, by the way, on the structure with the lot with the structure. The reason we're proceeding and asking for the waiver of the Portland cement is that they will be using heavy equipment with tracks, and if you were required to put in asphalt, you would just dig it up repeatedly. So compacted millings will do an excellent job. Scott can deal with that from his experience. It will not be a dust issue. It is would cover the vast majority of the lot, and that would be where the laydown area would mostly be used. It's also impacted negatively in the fact that the Salisbury River is right in the rear. It's subject to the Rivers Act. It has floodplain issues, which eliminates a substantial portion of the utilization of the lot in question. So this is a reuse that I think is an excellent opportunity for the city of Brockton. It's an excellent first-rate company, and if you are inclined to grant the variance, really under essentially the same standards that we granted the prior variance in its appearance before this board, the corporation will be ready to move in and get work right away. So I provided notification to the ward councilor of the material in detail to allow her to have an opportunity to review it, and it appears it was fine. So I think that's it. Unless there are any specific questions, I'd be happy to try and respond.
Yeah, Mr. Chair, if I could, there's a lot of parking there. How many employees between the both of them?
Mark, come on, you got to speak to this, okay? And name and address. And
good evening. My name is Mark Schmidt, and I live in Wyckoff, New Jersey, which is just nearby where Patterson location is. So I would say in the office would probably be between 6 to 8 people. There will be mechanics in the shop that we have there for repair of the equipment, and then probably 2 or 3 in the yard working, to the best of my knowledge at this point.
Okay.
All right.
What types of materials, when we say materials, what will be on site? Are we talking, what will be held there?
Well, it'll be a variety of things. It could be from just rails themselves. It can be from the ties, railroad ties. It can be, there will be piles that sometimes of gravel or whatever we need at the yards that we're servicing right now in downtown Boston. Basic construction material for the rail system that we'll have there.
Fenced property?
Yes, it is.
Greenery, like shown?
It already is fenced, both yards are.
Mm-hmm. Okay.
And I think we have security cameras too.
Okay.
Mm-hmm.
Are you going to have creosoted railroad ties here?
I believe so, sir.
Can you tell us how high those are stacked?
In the other 2 to 3 yards we have, I don't recall seeing them more than 4 to 6 feet high.
How many?
4 to 6 feet high.
Okay, they're not going to be 20 feet high?
No, absolutely not. No.
Do you guys follow any type of policy, how far you keep those stacks apart for conflagration issues?
Maybe, but I honestly don't know personally.
Okay. Big corporation, I'm sure that you have something that tells them they have to be so far apart. I'm not worried about that. I think you have to understand my concern of all this wood. You know, it might be 4 to 6 feet high, but there's going to be multiple 4 to 6 feet highs, potentially, if you're doing a lot of work, correct?
It could be. I'm not certain. I'm kind of new to the company, so I'm learning as I go here.
Gotcha. Okay.
To address one comment from the chief, we've created a buffer that doesn't exist right now, that will buffer the vacant parcel that will have the open materials. And essentially, the building totally hides the rest of the rear structure. So there will be basically minimal visual impacts, and certainly better than what exists now.
So this building doesn't have a building on it? I mean,
No,
this plot does not have a building on it?
It does not. It's a vacant parcel. The one with the millings does not.
And pieces of, how many, like, you're going to have equipment there, probably like front-end loaders, forklifts, stuff like that. Are you looking to have a lot of, will there be a lot of equipment on site? And will there be servicing issues, fueling issues? How will that all just work?
The best of my knowledge, the equipment will vary in size and number. This is evolving, this yard, and the use of it and servicing of the city area. If I were to quantify it, I would say probably 20 to 30 pieces of equipment, which would be, if it's not on, most of our equipment is on the site, and at times there's transitions of one site to the next. It could be a holding area. And the equipment or the machinery will be serviced in the garage that is currently there. And it's been servicing other equipment up until now.
Fueling. Will there be an on-site fueling tank? Or will they fuel?
I don't think so at this point.
We don't have anything.
Nothing. So they'll be bringing maybe like Burke or someone on site to fuel.
And there are, around the back, there are existing overhead doors.
Yes.
Part of that business, floor drains, oil water separators as required by the plan.
Okay.
Their use is just kind of an extension of what's going on there now.
Understood.
So
Sorry, go ahead.
Save that for the next hearing.
Yeah.
What type of vehicles will be transporting the materials? Is there, what are your business hours, and are there traffic patterns to your business?
Probably the biggest flow would be early in the morning from the yard. I'm talking very early a.m. It would be tractor trailer at times to bring some of the equipment in from the site.
I think it's a dawn to dusk business.
Okay.
Yeah, I'm
So
sorry.
it's not like, it's going to be constant. You're going to have something ready for the morning, it's going to be gone in the morning?
Yeah.
Okay. And the hours?
Well, I think you could say 6 a.m. to 7 p.m.
Okay.
Tops.
Thank you.
You're welcome.
So this is just essentially a laydown area just for Massachusetts. It's not going to be holding supplies for your other states or locations?
This is our focus as Massachusetts. We just signed a lease last week for office space in Newton for 10 co-workers. Engineering will be there. So this is a big footprint that we're taking a step into for expansion of our business. And we're started off with a very handsome contract, so it's a nice way to begin our market growth up here.
Is your business going to service the MBTA, all this local rail that's being expanded on? Okay.
Absolutely.
Is that directly for this project?
Absolutely.
Okay.
I think I identified in my brief that they had a major impact, that they covered a very active line of the MBTA, and they managed to do it in 17 days. So they're professionals. This is what they do.
So would you find your location central to the rail, for the rail? Is that why you selected it?
I wish I could say yes to that. Closer to the city would have been better, but just the availability of property and is very scarce. So it works right now. Our commute time is probably 35 to 45 minutes at the hours we travel in the morning. So our site, we're in Cabot Yard and Southampton area right now is our big focus. Okay.
Thanks.
I think we need to be a little bit careful on hours. Somebody just mentioned, what, 6 to 7 or something?
Yeah.
6 a.m. to 7 p.m. Generally, those are contractors' hours.
Yeah, so I guess my concern would be if something happened, for example, on the MBTA rail, would your company employees be required to work on a Sunday or a holiday?
The answer to that is yes. Yes, we do provide emergency service. It's one of our specialties and one that's in demand, but I think it's more of an exception than the norm at this point.
I'm just wondering where they are, it sounds like an operation that could get called out at any time for whatever reason, that it might be a burden to set hours on it, and yet I would expect that they would be good neighbors, that probably, like you say, 7 o'clock at night, place is going to be shut down till the next day. But I'm just concerned that if something happened and you had to go out at 8 o'clock, or you're not going to get back until midnight, I don't know how much of a problem that's going to be. Should we just, there was no hours on the last one.
Okay. If it's an emergency,
leave it alone.
it seems like it would be an emergency. If you needed something to go out right away, it would be imperative to restrict that.
Anyway, that was my thought. And the other thing that upset me as I read through the last variance we granted down there, we were very specific on this lot, this vacant lot, and they 100% agreed that they would have 10 feet of green space from the fence, from the back side of the sidewalk to their lot. And they were going to landscape that, put some trees. The next lot down that we're going to deal with next, they did a beautiful job landscaping that lot where their building is. But this lot to the north that we're talking about right now just never got done. So I will open that up for discussion.
That's in our plans, Chief.
It is?
Yes, we have a detailed planning for that area. Scott, you want to address it?
Just as you said, Chief, it's just landscaping across the front, similar to what was agreed upon.
10 feet.
Yes.
I'm going to be watching.
Okay.
You know we will be.
So, Scott, can you just tell us about this milling that you would put on top of the ground? What?
Yeah, so the millings, the construction costs are a lot less. Obviously, the advantage and the reason why most contractors want to use them. Other towns, West Bridgewater, Easton, Stoughton, allow millings for these type of things, for truck storage, for fleet storage. As far as drainage in the environment goes, once they put it down, it really packs down tight. It's almost as hard as the blacktop would be. So from a drainage point of view, it's still almost 100% runoff. So we still need catch basins, manholes into drainage systems, just like we would have in a regular parking lot. So in this case, we would need to file with Conservation Commission as it is in the buffer zone in the riverfront area. So we would have to do a large detention basin in the back on the millings lot, similar to what's on the paved lot next door. Same exact thing. So drainage-wise, from an engineering point of view, it's going to look exactly like its neighbor.
So is the milling like what they take off of the top of blacktop?
Chew it up and
Chew it up,
into the
yeah.
tractor. Yep.
Okay, I understand, okay. Just so I get a good feeling.
And it does. It packs right down just like.
I think they call it reclaim, too.
Right.
Yeah.
Yep.
Yep.
All right, I don't know what else we could ask on this thing. I think it's going to be secured at night, gates closed type thing,
Yes,
keep
absolutely.
people out of there?
Absolutely.
And lighting?
Stan, is there lighting in the whole yard? Probably not on the one that's just dirt right now. We definitely will have lighting on there.
So I guess I don't want to see lighting that's going to be obnoxious. However, for security purposes, spillover of lighting down there may be a good thing rather than in a residential neighborhood. So I would encourage you to light that up so that, yeah. All right. I will close that portion of the hearing. Now I'll open it up for, is there anyone here that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Wait a minute, what do we got here?
Hopefully not opposition, he's the owner.
Opposition?
Works for the company?
No.
I'm sorry, you got to jump up quicker. You want to speak in favor? Go right ahead.
My name is Stan Silver. I am the current owner of the properties. I just wanted to say that I think this will be a great thing for our city to have this big company wanting to come to our city to set foot here to service the things that they do. I think it will be a good thing for our city. As far as the area, I think the area is great for that. We've had trouble keeping businesses in that part of town, but this company doesn't need foot traffic, doesn't need all frontage. But that will be a good company that we need in that city, that we need in that area. So that's what I got.
So did you hear my comment about the green space? Or you just want to pass on that? All right, good. Thank you.
They'll take care of it. I left it for them.
Is there anyone else that wants to speak in favor? Seeing none, I'll close that portion of the hearing. Is there anyone that wants to speak in opposition? Seeing none, I'll close that portion of the hearing. Is there any elected official that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone that has a question relative to the testimony that has been given tonight? Seeing none, I'll close that portion of the hearing. That concludes the public discussion. I'll now open it up for deliberations by the board. Board members.
I think it's a good project. I mean, that's where we want this stuff in the city. It's bringing commercial real, it's working with the commercial real estate. I think the milling stuff, I think they put blacktop in there, it's going to get chewed up and look worse than the millings, you know what I mean? So I think this will be nice to see down there.
I really think that this side of town is starting to find an identity where it was desolate. So I think it suits the environment, and I think it suits the zone.
We've approved similar things in that neighborhood, up across from Sergeant's Way all the way down to the West Bridgewater line. So I'm hoping that this is a national company that will be a good neighbor. I get the feeling that they would be.
Make a motion to grant.
Second.
On the motion, we should put a stipulation in there that there shall be green space along the front of the lot, no less than 10 feet wide, landscaped.
Agree.
We good with that?
Yep.
Okay, motion has been made and seconded to grant. Clerk, please call the roll.
Mr. Lanus?
Yes.
Chief Nardilli?
Yes.
Mr. Sweeney?
Yes.
Ms. Greenberry?
Yes.
Chair Galligan?
Yes.
Mr. Chair, that 5 in the affirmative, 0 in the negative.
The vote is 5 in the affirmative, none in the negative. The petition is granted.
Thank the zoning board for its time.
Thank you very much.
You're not done yet.
Jim? Mr. Burke?
You still got another one.
I apologize. What was that great radio host, Ditto?
Well, we're not far from that. All right. Case number 2774. Petition of Railroad Construction Company, 7577 Grove Street, Paterson, New Jersey, for a variance seeking relief under Section 2729 to be allowed to occupy and use an office, garage, warehouse, repair facility with exterior storage of materials and equipment in conjunction with its construction operation in a C2 zone located at 1854 Main Street. This is the existing building that's there now.
And I would say that the legal term would probably be, I seek to incorporate by reference the prior testimony and make it applicable to this specific hearing.
Board members, we okay with that?
This is where the building is. This is where the garage and service will be. I know Scott spoke earlier about all the. Now, will there be millings on this side as well?
No, that's fully.
This is fully. This will be fully blacktopped.
Paved all the way.
With paved. That's what I thought. Okay. All right. That's all. And lighting will remain the same.
Yeah, there are existing lights throughout the parking lot.
Gating and security.
It is gated right at the driveway heading down.
And the operation of those hours would probably go along with, because if people are coming in emergently overnight, if there's an issue on the rails, hours of operation would probably be similar then, right? Potentially? Basically unknown. Okay.
I think it's imperative to put it out in the public that we are considering that this company could do emergency work on rails, and we are giving them the ability to come in at odd hours to do things, but we would certainly expect that if they don't have to do that, we wouldn't see crazy hours of operation. I think we're being very flexible on the hours, but I think the company is probably reputable enough to understand what we're talking about. Where'd he go? There he is over there. So you understand what we're talking about here?
Very much so.
So to that point real quick too, and I think you're doing emergent operations after hours, the lighting that will be in that other lot will not be significant for those machine operators if they're operating machines. They probably have to have some sort of generators with lights. I think that would have to obviously be a concern that those are made sure they're shut off at the end of getting their materials if they have to leave emergently. And I don't want to beat this horse here. I know this is maybe something that might happen once a year, if that, but I think it's important that we talk about that.
Not that it's a great impact, but it's a fully unionized operation. So in terms of the flexibility, I mean, if they have to go out, they have to go out and it has to be negotiated. So,
Sure. Understood.
I agree. All right, so on a ditto presentation, is the board all set with your questions? All right, I'll close that portion of the hearing. Is there anyone here that wants to speak in favor? Anyone that wants to speak in opposition? Seeing none, is there any elected official in the room that wants to be heard on the issue? Seeing none, I'll close that portion of the hearing. Is there anyone in the room that has a question relative to the testimony that has been given tonight? Seeing none, I'll close that portion of the hearing. I will now open it up for board member deliberation. Board members.
I just think for the transparency of us talking about it, I think it's just, same stuff we talked about before. It's a good project. It's in that same area. It's going to keep that area bustling. I think one of my only concern with both of these is obviously that early morning traffic. I would say people coming from distances, I would think they'd be coming from 106. Material would be going back out down 28 to 106, not driving through neighborhoods. And that would be the easiest way, probably, which is beneficial. I know we've dealt with this a number of times on the north side in a lot of those industrial areas going up into Avon. So I think, not that we can't adjudicate that in any way, but I think it's important.
it's the path of least resistance.
Path of least resistance will make it work, so, good. I have nothing further.
Motion to approve?
Second?
With the stipulations, we
Green
didn't have
space.
any on this one, right? The green space is already there. Everything's all built out. We're happy with that? Okay. Will the clerk please call the roll?
Mr. Lanus.
Yes.
Chief Nadelli.
Yes.
Mr. Sweeney.
Yes.
Ms. Greenberry.
Yes.
Chair Galligan.
Yes.
Mr. Chair, 5 in the affirmative, 0 in the negative.
The vote is 5 in the affirmative, none in the negative. The petition is granted.
And I thank the board for its time.
Thank you very much.
Good luck. All right, before we close tonight, before Sweeney has something to say, I want to wish the board a happy holidays, Merry Christmas, Happy New Year. We won't see you till next year.
Happy holidays. Motion to adjourn?
Second.
Motion's been made to adjourn. We are adjourned.